May I, Lordship? Regarding item number 1, my leading counsel advocate RCOK is out of station for some personal reasons. For that, I'm seeking an adjournment for today.
On the ground that Mr. RCOK counsel for the petitioners is out of station. Prayer for adjournment is made. So prayer is allowed. List
Immediately after interim break, Your Lordship.
list after vacation.
Obliged.
Please, Your Lordship. Commonwealth's Lordship filed an affidavit saying that the committee has recommended my name. So the matter can be closed. Yes.
Then let's go. The petitioner in this petition was convicted by the Deputy Commissioner cum ex-officio Sessions Judge, 0, Arunachal Pradesh, by judgment and sentence dated 23/7/2004 in connection with Sessions case number 1 of 2004 under section 302/392/397/457 IPC. So the petitioner was sentenced to undergo rigorous imprisonment for life with fine of ₹50,000 under section 302 IPC, semicolon, RI for 10 years with fine of ₹5,000 under section 392/397 IPC, semicolon, fine of ₹5,000 this fine of 5,000 is for the 392/397.
Yes.
Or then not 30. It will not be 5 with default sentence. First of all, the petitioner projects that the fine of ₹60,000 has already been paid by Treasury Challan dated There's something wrong. If
Lordship,
it is 55, why you pay 60?
Lordship,
If the fine is 55, why need you pay 60?
Lordship,
Where is the sentence part of the judgment?
sentence part of the judgment, Lordship, will be.
You have not annexed the judgment?
Lordship, no, the judgment has not been annexed.
What is this? Okay, then number 3 will be there, not with default. Number 3, that is 5,000. The fine amount is 5,000 for offense committed under section 457 IPC. Next one. The fine amount is 60,000 has already been deposited. White Treasury Challan number 8605 dated 4/2/2020. It is projected that the petitioner has completed judicial incarceration of 25 years, 3 months, 50 days. 3 months, 50 days is something wrong.
On the date of filing of this.
50 days is 1 month again.
Yes, we have written it like this, but.
6, this 4 months, 10 days. Accordingly, a prayer for remission was made by the petitioner, who is presently undergoing life sentence at North Lakhimpur Jail from Assam. Though the prayer for remission was sent to the appropriate authority in the government, as no decision was taken, the present litigation has been filed under Article 226 of the Constitution of India. Next paragraph. The learned senior government advocate has referred to the affidavit in opposition filed on behalf of respondent numbers 1 and 2, wherein it is stated that the name of the petitioner was recommended for remission by minutes dated 4/3/2025 by the state level committee. So accordingly, this recommendation was submitted to the appropriate government on 28/3/2025. Now, Mr. Luang, in your affidavit, please come to page 138.
Yes, yes, sir.
Last 2 lines, please read.
The last one.
Last 2 lines, please read. This sentence, please read.
From accordingly, Manathi.
Yes, please read.
Accordingly, the aforesaid recommendation of the state level committee has been submitted to the state government. on 28/3/25, for consideration of approval of remission
So
and
it is still,
premium.
again, consideration. This doesn't mean that the state government has granted remission. It's only a recommendation made.
Recommendation. has been made.
Recommendation, yes. State level from this
But the government will still have to
committee,
take a decision.
it is not decision of committee, Manas. For decision of the government, they had recommended names of these persons.
We understand, but you see, the prayer was to close it. We can't close it now. Till the state government takes a decision, we can't close it.
Yes.
Next para, accordingly. Next para, accordingly, taking note of the recommendation of the made. And that the matter is pending before the appropriate government since 28/3/2025. We hope and trust that the competent authority shall take an appropriate decision on such recommendation made on 28/3/2025 by the state level committee. Hopefully, within a period of 3 weeks,
Yes.
correct?
Oh,
3 weeks. Next paragraph. The learned senior government advocate shall send a downloaded copy of this order to the
Respondents 1 and 2.
respondent number 1. Bring the order to the notice of the said authority. So as to enable the said authority to trace out the said recommendation dated 28/3/2025 and to pass appropriate orders thereon. As the government may be so advised. Next paragraph. This give a date after 3 weeks. 6/5/2025.
Oblige. Much obliged.
Oh, just a moment. What is this? Oh, it's Oh, it's granted.
yes, yes, yes.
That copy is no idea.
You've not seen this?
No.
Oh. Please.
I
Sorry.
think government is
I did
writing,
not notice it.
already written to this thing, yellow
I did not
authority
notice
also.
it. Don't write that. Next one. Next one, the learned senior government advocate has produced a copy of order number. This is it, huh? Order number is so dated 2/4/2025. By which the Principal Secretary to the Government of Arunachal Pradesh from our Home Department has communicated the decision of the authority, decision of the government to approve the premature release of persons whose name appear in the said order, which includes the name of the petitioner
Serial
Number
number
1. Serial number 1.
at serial number 1. Sri Koda Tagia, within bracket, mail number AC of the 2486, bracket closed, lodged in district jail, Teju, Lohit district, Arunachal Pradesh, on conditions as mentioned therein. And it appears from the said order that on 8/4/2025, a copy of the said order has already been communicated to the superintendent, Deputy Superintendent of Jail, District Jail, Teju, Arunachal Pradesh. Next part. In view of the course of the constituted opinion that as the appropriate government has approved the premature release of the petitioner, no further order needs to be passed in this writ petition. Next, but according to unsatisfaction, this writ petition stands closed.
Obliged.
ये कर लेगा हाँ
Your Lordship,
Yes.
I beg to mention item number 8, Your Lordship.
8.
Yes, Your Lordship. May be fixed after 2 weeks, Your Lordship.
Okay, you have info.
I have already taken the consent, Your Lordship.
Both sides are represented on the prayer made by so I Ram and the government advocate. Release the matter after 2 weeks.
Obliged, Your Lordship.
My Lordship, I have to mention item number 18, Lordship. I may be allowed to withdraw this petition, Lordship.
18. Okay.
18, Lordship.
Upon instructions, Mr.
K. Lolin, Lordship.
K. Lolin,
Lordship.
learned counsel for the petitioner, seeks to withdraw this writ petition. Mr. Y. Ram and government advocate is present. The matter stands dismissed on withdrawal.
Obliged, Lordship.
Okay, any interim order is there?
No, Lordship.
No.
May I, Lordship, I beg to mention item number 7, 9,
7 and 9.
7, 9, Lordship, and 13, 14, 15, 16, and 17.
Don't be so fast. Item 7.
Yes, Lordship.
Yes.
13, 14,
7, 13, 14.
15, 16, and 17. Lordship, in this matter, I'm appearing on behalf of Senior Standing Counsel, Tabatagon.
My lord, in item number 7, I put a petitioner, my lord. My brother, my lord, matter will be listed after 2 weeks.
Okay.
It is termination of
Yeah.
service of the petitioner.
Okay. And in other matters, you have taken consent of Mr. Tapu?
Yes, Lordship.
Okay.
Lordship, this other matters may fix after 3 weeks.
Item number 13 to 17, Your Lordship. Readings are complete.
Okay. Both sides are represented. On behalf of Mr. T. Tagum, standing counsel for the Education Department. Verified adjournment is made. If prayer is allowed, list after 3 weeks on a date to be fixed by the registry. Okay.
May I please, Your Lordship? Your Lordship, I beg to mention item number 11, Your Lordship. Here I'm for the private respondent number 4 and 5, Your Lordship.
Okay.
Readings are complete, Your Lordship. Matter may be fixed for admission hearing, Your Lordship.
If you are ready, we can take it up today also.
Your Lordship, moreover, Your Lordship, conducting counsel is not available today.
Both sides are represented. Counsel for the private respondents, and the case is ready as regards service and pleadings. Accordingly, list the matter after 3 weeks in the admission column. Okay.
Highly obliged.
Your Lordship, I wish to mention item number 12. I'm appearing on behalf of petitioner. The conduct the consular order station.
Prayer made by one counsel for the petitioner. Yes. See, both sides are represented, and the prayer made by one counsel for the petitioner. Just after 3 weeks. Okay.
Matter may be listed after 3 weeks.
Huh?
Matter may be listed after 3 weeks. Obliged.
Yeah, Lordship. That's why I beg to mention item number 12. On behalf of petitioner,
He's just taking adjournment.
listen.
Yes, you can catch him.
Oh, sir.
You substitute a name then.
May it be Lordship.
Yes.
Lordship, this petitioners working as a sub-inspector since the year 2012. In between, there is some trend of the government to constitute DPC in the year 2023. That was later stayed by the Honorable Court, and again that stay was lifted.
Additional notice, you are representing against the seniority list.
Yes, sir. So,
Mr. Sharma, and counsel for the petitioner. The petitioners assailed the seniority list published on
case number
just give me the date
13/9/2023.
13/9/2023. By filing this declaration under Article 226 of the Constitution of India. If you notice, returnable in 4 weeks. Mr. S. Tapil and the senior government advocate accepts notice for the.
All the rest.
No, but where is the seniority list and what is your position here?
Lordship,
Which page?
Page 93, Lordship. Yeah, actually, what happens, Lordship?
Just a moment. '93.
Yes.
And where is your name?
This is related to page 93 civil police. There is 3 wings. I am from the IRB, Lordship.
We are just asking you, where is
97.
your name? Your 4 petitions
Page
are there.
99, it starts from serial number 11 at page 97.
Page
97.
97. But then none of the parties will be affected are added as respondents here.
No, Lordship, because my basic prayer is that DPC may be considered and our case may be considered, because there is a WTO message by which our names were referred for consideration of promotion, but that was later stated in this honorable board by another order directed the government to continue with the DPC process. Consider the DPC. First, we see page 83, 11 portion of this honorable board's order.
Where is your representation?
Representation is at page Lordship. One free in the 30.
Your representation is for conducting a DPC,
Yes, Lordship.
but
My prayer also-
but the seniority list you are showing is only a provisional seniority list. What is the connection between the two?
No, Lordship, my prayer is not with senior listeners.
I don't know. You see,
Come to my prayer,
please,
Lordship.
can you do not expect me to read each and every page and then come? You show me a letter.
No, Lordship, kindly come to my prayer portion, Lordship. It is page 27.
Yes.
writ of penance, one, a writ of penance shall be issued. It shall not issue to direct the responsible authorities to consider DPC and place their case in for consideration under the service applicable at the time post held vacant and promote the petitioners to the post of APPS entry grade in the Arunachal Pradesh Police Service as per Arunachal Pradesh Police Service rules 1989 with effect from the date of their eligibility, and set aside the letter date 21 to 24 considering the vacancy thereof before coming to 4/2020 amendment. These are my prayers, not mainly on seniority list. So my prayer that also notice today. Because in the year 2022, after the last DPC, 19 posts for promotion fell vacant.
Which page is your representation? On 1-3. Well, then this change that order. It will be by the petitioners project that how many posts have fallen vacant? How many posts are fallen vacant?
Post 19 post lordship.
Okay. 90
for
posts
APPS
of
entry grade.
APPS within bracket entry grade.
Yes.
Of the rank of Deputy Superintendent of Police, of the Assistant Commandant, which are required to be filled up by promotion, as they have fallen vacant since
2022.
Since the year 2022, and the said posts are required to be filled up by promotion from the eligible senior-most inspectors of the police organizations of the state, like APP, AAPB small n and IRB small n. However, as timely DPC has not been conducted, the present date petition has been filed under Article 226 of the Constitution of India. Issue notice, return within 4 weeks. This has been done at senior government advocate accepts notice on behalf of all the respondents. Accordingly, requisite extra copies of the registration is served on him within 2 days. Next, the pendency of this registration shall not be a bar for the competent respondent authorities to constitute the DPC for filling up the post of vacant posts of AP. What is the name?
APPS entry grade.
Huh?
APPS entry grade.
AA
Double BS.
double PS within bracket entry grade.
Okay.
You also give a certified copy to whom? The certified copy of this, the
Commissioner,
respondent number.
respondent number,
Petitioner is shall produce a certified copy of this order before the respondent number. Yes.
Two laws.
That's number 2. To bring the order to the notice of the said authority. Okay, number 2, item number 2. Item number 2.
May I please, Your Lordship? On the last provision, my lord has already seen the impure not NIT, my lord. My lord,
Oh, yes.
technically, my lord, only one day, my lord. NIT, my lord.
My lord, again, this matter. The firm is representative, one of the representatives. So the proprietor of the firm is not before this court. And there is no any authorization letter. Moreover, this work was only meant for those contractor of the Sagali constituency as per district-based entrepreneurs. So he is not qualified to apply also.
Where is that condition?
Page 24, annexure 5, he have annexed.
24.
Page 25, relevant.
Yes.
Serial number 5, above 3 crore and up to 8 crore, all registered contractor in class 2 category domicile within the territorial jurisdiction of assembly constituency. So as per advertisement, Sagali assembly constituency, those contractor registered within the territorial jurisdiction of Sagali constituency.
What is the tender value?
My lord, advertisement is written 21 page.
20? 21. Which serial number?
Page 21, advertisement clearly mentioned.
Which serial number?
Serial number 5, my lord, page 25.
Serial number 5.
That is district-based entrepreneurs. Above 3 crore and up to 8 crore. The next eligible contractors. All registered
No,
contractor.
in this page 21, which is the contract?
Page 21 is the advertisement. So advertisement was in only those contractors who are bona fide.
No, we understand, but there are 7 contracts here. This contract is for which one?
This is one for serial number 1.
Serial number 1.
Which is challenge is 5 crore.
Serial number 1 is 5
crore, yes.
0.5 crore. Yes. Okay. Now this. Serial number 5328 crores is only this. Then Mr. Kato, we can't do anything. Then you can't be an aggrieved party.
My lord, basically, I'm for the my lord, item number 1, Lordship has seen the first NIT. My lord.
But this page 25 disqualifies you.
Yes, my lord.
So you can't be aggrieved.
My lord, only for the serial number 1, my lord.
Yes.
And my lord, of course, my lord, the registration is, it talks about, my lord, the persons who is from that area, my lord. So therefore, my lord, the proprietor of this firm is, my lord, belongs to that particular area, my lord. The documents I have not, admittedly, my lord, not enclosed. My lord, if Lordship perused, my lord, my lord, page number 20, my lord. He is the proprietor, my lord.
This is firm register.
Firm register, enlistment, contractor enlistment, my lord.
If the office is registered at Bandardeva.
My lord,
Yes.
office can be, my lord, anyway. My lord, this as per the, my lord, my lord, Lordship has seen the page number 25.
I fail to understand. Let us say the proprietor resides in Bombay.
My lord.
He has a firm registered in Delhi.
My lord.
Correct.
My lord.
So the proprietorship firm and the proprietor is coexistent with each other. They are same. Correct. Now, if you have a registered office as a contractor in Delhi, can you say that the firm exists in Bombay? Firm
Mal-
does not exist, the person exists,
Person exists, my lord.
but the firm does not exist.
My lord,
You are-
as per my lord, if we interpret my lord, the page number 25 again, my lord, this talks about all registered contractors in class 2 categories
Domicile.
domicile within the territorial jurisdiction of the assembly constitution constituency.
all registered contractors in so and so domicile within.
My lord, it seems, my lord, the domicile,
Contractor, this person is not registered as a contractor.
my lord. My lord, it is within the jurisdiction, my lord. Assembly of, admittedly, my lord, the assembly constituency is, my lord, Itanagar, my lord, it registered, this Bandadua comes under the Itanagar, my lord, capital, my lord, Itanagar, my lord. Itanagar, 14 at Itanagar ST Assembly constituency, my lord. But my lord, the project where the NIT is going, my lord, the project is going to be constructed at the different constituency where I belongs to, my lord.
I don't know, just tell us simply that this man, this firm is registered, the petitioner firm is registered as Bandardeva. Is the Bandardeva and the, this
But my lord,
Taru at Papum Pare,
It
they
is-
are in the same association,
Yes.
same.
District is there.
assembly segments are different, my
If it
lord.
is more than 8 crore, then he can participate. There is no.
No, then he can participate here also.
Yes, my lord.
No, this is assembly, there is segregation, my lord. Block assembly constituency, there is block wise also. As per,
I don't know, please, whatever you are referring, you show me that. You are referring to page 25.
yes, my lord,
25 is assembly constituency.
yes.
So my question is this Toru in Papumpare, is it within the same assembly constituency as Bandardeva?
No, it's separate.
Admittedly, my lord.
Different?
Yes.
Then you can't participate.
My lord, as per the, my lord, the domicile, my lord, assembly, my lord. I am domicile of that assembly constituency, my lord. My registration is within Papumpari district, my lord.
But his address
But-
is also given Itanagar.
I am personally belongs to that category, that assembly
You
constituency.
can't help it. You have to re-register yourself at this place.
My lord, that is the only fair, my lord.
You can't do it. Those person includes under the, under the, yeah, what you call it? General Clauses Act. Person includes a firm. This person is not registered. The domicile of the firm will always be that place
My lord.
where it is registered, because you don't have GST number for yourself in the name of the firm registered at that wherever your hometown is. Because if I just tell me the law, if I'm not very clear, if in the GST you have 10 establishments, say within the city, do you have to have a separate registration, GST registration?
My lord,
For
GST,
every shop you have?
my lord, for GST registration, my lord, to my understanding, my lord, it is only the registration where it can be done, my lord. Address is only required, my lord. The GST will remain the same, my lord.
Just give the GST Act.
GST number will be remain the same, my lord.
Hmm?
GST number will be allotted only one, my lord. Though address may be indifferent, my lord.
No, 25 to proviso. Twenty-five to proviso.
Person seeking registration under this state shall be granted a single registration in the state or in a the provided that the person is moving to multiple places of business in a state or union company may grant the separate registrations for each such place of business subject to such condition is very question. And this proviso is basically it is possible where another having multiple business place of business.
No, no, you see, when you have a,
My case is, I'm moving only concern with public park district. The public park district is the same,
that means for all purposes, you do business through Papumpare. Then you are registered, then you can't say that domicile will give you the cause of action to come here. It's not constitution, we can't help it.
And even though in other districts, everything other constituencies are different. But
We can-
same district.
You can only hope you join politics and change everything. Well, this time Katul and it comes for the petitioner. Also heard. Mr. You are appearing for all?
1 to 4.
One to four. Okay, Mr. Jila, right, and it's standing counsel for the RWD, except appears for also at Mr. Jila, right, and standing counsel for the RWD, representing respondent numbers 1 to 5. Next paragraph. The respondent authorities where will you find it? Huh? District based. Use the book. Which page is that?
Page number 2, she plots it book page 233. Or otherwise, it's same page number 24.
There's some person who does not want to read me to read this. 233. Yes. Section.
Section 2, subsection B.
Yes.
Definition of district based and professional leave and includes any person who is involved in activity for execution of development and welfare protection of government and includes architect, engineer, contractor, doctors, etc., but does not include any government official. The person must be having local, must be local having permanent domicile certificate and is a permanent resident of the district.
You see, nothing in the legislature can be presumed to be bad or what you call, or it can be presumed that the same is irreconcilable because of the fact that in schedule, which is appended to this act, you see,
eligibility, of course, I know that the serial, but eligibility is completely different from the
okay, this amount is rupees more than 5 crore. Huh? Amount is how much?
500, 5 crore.
5 crore, 5 lakh,
5
almost.
crore.
5 crore, 5 lakh. Then you see the schedule at 3, Mr. Tarak has reached 235. This will be district, not assembly. Show him the book. But then you have to challenge it, Mr. Kato. Unless you challenge it, we can't do anything. This tender condition to make it assembly wise, that perhaps you'll have to challenge now. No, then you have to challenge it.
This is his document, the amended in 2020. This
Huh?
annexure is amended in 2020.
2020.
Yes, amended.
Which page?
The page 24 of annexure 5 of the petition.
Okay, substituted by Act 7 of 2020.
From 5 crore to it raised to 8 crore,
Just a
up
moment.
to 8 crore.
Oh. Yes. That is why perhaps nobody wanted me to read it. That is why perhaps it was sealed. Next para. The case of the petitioner is that his firm is having a registered, the petitioner firm is having a registration office, has his registered office at Bandardeva within the district of Papumpare. The petitioner projects himself to be a class. What is a class of class of registration? Class of a registration 1A or something like that. Class is registered as class 2 contractor. First off, the grievance of the petitioner is that the respondent authorities had issued impugn NIT dated 12/3/2025, amongst others, for construction of 120 bedded hostel for government secondary school, Circle Toru, TURU, in the district of Papumpare at an estimated cost of rupees 5,04, 90,000 manually, which is stated to be in violation of the general financial rules. Rule 160 within bracket small I of the general financial rules and the stipulations contained in the CPWD works manual. First of all. Moreover, it's projected that the time to purchase tender was open only from 3/3/2025 to 15/3/2025, during office hours. And that the last date of submission of tender was 15/3/2025. So accordingly, insufficient and inadequate time was provided in this tender process. Accordingly, comment is submitted that the respondent authorities have not conducted the tender process in a free, fair and transparent manner. Also submitted that very limited tenders were submitted in this case, and the working question was awarded to the respondent number 5. Next, accordingly, from the said tender process and the award of contract to the respondent number 5 was issued the letter of acceptance dated 22/3/2025. It's challenged by this writ petition filed under Article 226 of the Constitution of India. Next, issue notice returnable. Oh, no, sorry. Next, the opposing the maintenance of the writ petition, the Donald Standing Council for the RWD has submitted that as per the Arunachal Pradesh district-based entrepreneurs and professionals within bracket incentives, development and promotional bracket Act 2015 as amended by Act 7 of 2020 with effect from 2/11/2020, in respect of contracts, public works, which are having value of cost of above rupees 3.00 crore and up to rupees 8.00 crore are open for bidding to those eligible contractors who are registered in class 2 category and domiciled within territorial jurisdiction of the assembly constituency. Accordingly, it is submitted that as the form of the petitioner is registered in Papumpare and the work for which the petitioner is now setting up a claim. The serial number 1 of the press tender notice dated 12/3/2025 is not eligible. As the work in question is at place called Toru, Toru, in Komado, which is in Papumpare district, is under different assembly constituency than the address where the petitioner is registered. You know the name of the assembly constituency? 15 Sagali. Which one? No, the Papumpare is which 13 Sagali. 14? How do I spell it? 14? 14, the name or assembly constituency, how do I spell it? 14 dash. Doimuk. DOIMUKH. Assembly constituency, whereas work is at 15 Sagalid assembly constituency. Next paragraph. Counting the statement made by the learned standing counsel for the RWD, the learned counsel for the petitioner has submitted that though the firm of the petitioner is registered in Bandadeva in Papapara district, but the petitioner is a resident of the Toru, TORU locality, and therefore is eligible to participate. Next paragraph. Consider the materials available on record and also consider the submissions made by the learned counsel representing both sides. Next paragraph. The schedule to the (2015) Act provides as follows. For cost of work above rupees 3.00 crore and up to rupees 8.00 crore, under eligibility of contractor column, it is provided as follows: dash inverted comma start, all registered contractors in class 2 categories domiciled within the territorial jurisdiction of assembly constituency. First up. Therefore, comma, if the petitioner does trade or business in a name different than his own, and the said trade name and the firm is registered at Badladeva in Papampara district, comma, a mere domicile of the petitioner in a different locality would not make him eligible to submit a bid in light of entry 5 of schedule to the said 2015 Act, as the said provision refers to registered contractor and not the proprietor of the registered contractor. Next, accordingly, the objection to the materiality of the petition, raised by the learned standing counsel for the respondents, state respondents, is accepted. So, according to the petitioners found not found to have locus standi to challenge the present tender in question. So, according to this petition stands dismissed at the motion stage without issuance of any notice on the respondents.
Item number 3.
May I please, Your Lordship?
Yes.
I'm sorry, for a sudden call, I couldn't physically go there and appear before Lordship. My lord, in this case, there is a history where earlier both the counsel appearing for the two sides had occasion to appear in a different round. But the subject matter with your lordship in this case is
The difficulty is that when both of you appear, we expect fireworks. Which has not started. Which has not started till now.
I'm only holding a shield, not sword. So my learned friend is having a sword in his hand. So I only defend myself.
Okay.
Well, in this case, the grievance of the petitioner is that he is a member of a Jila parishad, which is a newly constituted Jila parishad of KE Petitioner Jila parishad. After new district was created by bifurcating Lower Subansiri district. Now, without giving notice and without following the procedure prescribed under Rule 67 of the Arunachal Pradesh Conduct of Election Rules, the chairperson of the newly created Jila Parishad is
election rules.
Well,
Yes.
without following Rule 67, the chairperson is going to be elected. That too from a group of members allegedly belonging still to the BJP party, my lord, because earlier because of the fact that there were anti-party activities by some of the members, including the persons at whose instance now the process has been initiated for electing the chairperson, they were disqualified by the deputy commissioner in terms of Arunachal Pradesh Local Authorities Defection Act, 2003. There is the whole case, my lord. Now here, I'm challenging the process of electing the chairperson on three counts, my lord. First, your lordship may straightway turn to page 30, my lord, is the notification.
Yes.
My lord, the notification is of 28th of March 2025, issued by the returning officer. Now, who has appointed this person as a returning officer is not known. Under what circumstances, under what authority he is writing that he is a returning officer, it is not known. Secondly, he is admittedly the additional deputy commissioner ADC, my lord.
Yes.
My lord, on top of the notification starts with the words under so and so Rule 67 of the Arunachal Pradesh Panchayat Raj Conduct of Election Rules 2003.
I'm just thinking.
My lord.
Excuse me for horrible examples I give.
My lord.
But let us say that you are appearing before the principal seat.
My lord.
When you submit that you are appearing in your official status as so and so.
Yes.
Do you produce the copy of appointment orders?
No, but then I must have the authority.
No, but we understand.
My lord.
But we understand. You see.
My lord.
Section 119, illustration G.
Yes.
There is a presumption that all official acts are regularly performed.
Evidence.
Absolutely.
Absolutely.
You'll remember 114G.
Yes.
We are from old school. We'll remember 114G.
Mine.
Not 119.
I have understood, my lord. My immediate response to this query by the Honorable Court is that here is a case where the person is admittedly and holding the office of additional deputy commissioner. There is no doubt about it. For this, he or she should not show under what authority he is doing. But then he is writing this letter in the capacity of a returning officer. My lord, in course of today's deliberations, your lordship will come to know none of the parties present before your lordship will be able to show that this person has been appointed a returning officer. My lord, I am not very much on this also. That is not my ground. My ground is, my lord, since he is acting in the capacity of either returning officer or additional deputy commissioner, he is not the authority to act under rule 67 of the rules. If your lordship straightway goes to rule 67, lordship, I think if a copy has been given to your lordship, my lord, lordship will kindly find rule 67 under part 6, election of chairperson of Gram Panchayat or Jila Parishad.
Yes.
The chairperson of Gram Panchayat or Jila Parishad shall be chosen by the elected members of Gram Panchayat or Jila Parishad from amongst themselves in the first meeting of the Gram Panchayat or Jila Parishad fixed by the deputy commissioner. So it is the deputy commissioner who will take the call, who will initiate the process, and will do everything for the purpose of enabling the members to elect a person, one of them as chairperson of the Jila Parishad. So in that view of the matter, my lord, the ADC who is apparently acting in the capacity of a returning officer, or maybe as an ADC also, has no authority under the law to initiate the process of electing a chairperson. That is my first submission, my lord.
Yes.
My lord, my second submission is the lordship, if your lordship goes again to page 30, where this notification is annexed, there is a extraordinary hurry in which the whole process is sought to be completed. Lordship has seen the schedule of the program. Date of nomination is 2nd of April. Time has been given, that is 10 o'clock in the morning. Date of scrutiny again 11 o'clock in the morning on the same day. Last date of withdrawal 12 o'clock. Last date on the left hand side, my lord, he is aware that how the date is to be given. Dates are mentioned. Last date of withdrawal becomes 12 hours, that is of 2nd of April 2025. Then date of call again, although it is date, it is mentioned as 1 o'clock on 3rd of April, next day. And date of counting 3rd of March, because there is an extraordinary hurry for which the counting will take place 1 month preceding the date of poll. That this date itself will render the entire notification null and void, because this notification is not a very simple notification that now we'll ignore this to be a typing error or something like that. If it is mentioned 3rd March, it has to be taken on 3rd March. That's my second submission. Now, my lord, the petitioner who is also a member of Jila Parishad is entitled to a notice. My lord, what has happened here, in a democracy, we know when there are 5 persons, my lord, in the newly created district of KE Panier, there are now 6 members, out of which 5 belong to Bharatiya Janata Party. We're not concerned with any party, my lord. I have to say this because they belong to a particular national party, recognized national party. Now, a person who will be ultimately chosen to be chairperson will have to be nominated by the party. Since there is a background, my lord, which possibly your lordship will recall, and I'm just now giving, my lord, what happened before the creation of new district and subsequent notification for creating a new Jila Parishad, my lord, these 4 persons who were in a hurry, they started taking steps to merge with another party, political party. So although new district notification creating a new district was published, but the notification under section 85 of the 97 Act, Panchayat Raj Act, was yet to be published, creating the new Jila Parishad. And by their several letters, they have made it very clear that they do not want to remain in the BJP. So they have expressed themselves to have merged with another political party. Thereafter, they were expelled. Then application was filed before the deputy commissioner for initiating a process for disqualifying them. After hearing all the parties, my lord, they were disqualified by the Deputy Commissioner. Lordship possibly will be recalling that they were disqualified. Then they approached this honorable court. They were disqualified on the 14th of May. Lordship may kindly take the notes, my lord, page 6. They have mentioned in we have mentioned in the writ petition. On 14/5/2024, they were disqualified by the Deputy Commissioner. And these dates are relevant for the purpose of showing that how the things have been done now. 14th of May 2024, they were disqualified by the Deputy Commissioner under the Arunachal Pradesh Local Authorities Prohibition of Defection Act 2003. Then they approached this honorable court by way of a writ petition challenging the order passed by the Deputy Commissioner disqualifying them. And this honorable court by judgment and order dated 30th of May 2024 in WPC number 211 of 2024. At page 6, my lord, they have mentioned it, we have mentioned everything. The writ petition was dismissed after hearing both the parties. Incidentally, both the counsel appearing before Lordship today did appear for their parties in the said proceeding. Then a writ appeal was taken, being writ appeal number 17 of 2024, that was dismissed on 27th of September 2024 by the division bench of the Sound Court. Then, my lord, SLP was preferred before the Honorable Supreme Court, where there is an interim order on 24th of October 2024. Unfortunately, this order has not been annexed. I have asked my learned friend there to hand over a copy to your lordship. Possibly, he will hand over a copy to your lordship, my lord. My lord, the lordship may kindly see the order passed by the Honorable Supreme Court, my lord. The order passed. Notice was issued and paragraph 6 is mentioned. Meanwhile, operation of the disqualification order dated 14/5/2024 passed by the Deputy Commissioner Lower Subansiri District shall remain state. Consequently, no by-elections shall be held till further orders. So there is an interim stay of the disqualification order, but the matter is still sub judice. At this stage, my lord, the hurried process has been initiated by those 4 persons who have approached this Honorable Supreme Court in collusion with the my lord ADC who has issued the notification to hold the election of chairperson of Jila Parishad in this hurried manner and without giving notice to the present petitioner who is also a member and without giving the party opportunity to nominate a candidate for the purpose of being elected as a chairperson.
Where is the requirements of the procedure which you are saying?
My lord, Rule 67, Lord, should kindly see. I was just about to read the other provisions of Rule 67, man. If your lordship has taken Rule 67, the first sub-rule 1 I have read. Sub-rule 2 says that the meeting shall be held at the date and time fixed by the Deputy Commissioner again at the headquarters of the Gram Panchayat or Jila Parishad and shall be presided over by an officer to be appointed by the Deputy Commissioner. All these rules, all these procedures have been violated. The notice convening the meeting, among other things, may specify the hour or hours during which nomination paper shall be received, scrutinized, or may be withdrawn. Now, the notification shows that you have got no opportunity during the course of the day, entire procedure will be over, more so when no notice was given to anybody. 4 says, if after the time fixed for withdrawal of candidature, there remains only one candidate for the office of chairperson, the officer appointed by the Deputy Commissioner shall forthwith declare him elected as chairperson in Form 26. Now, 5 is important. If there is no validly nominated candidate, the proceedings for seeking nomination shall commence afresh at a time for the purpose fixed by the officer appointed by the Deputy Commissioner. There is absolutely no nomination. Where is the question of validly nominating? They are fighting all throughout. They have approached the Honorable Supreme Court to establish that they are still members of Bharatiya Janata Party. And that is why if they say that I belong to a particular national political party, then minimum thing the party discipline envisages is that the nomination should be by the party, that this person is to be elected as the chairperson. Nothing has taken place. They themselves have hurriedly and in a surreptitious manner, they have done it without giving notice to the present petitioner and to others. Then 6 says, if the number of contesting candidates for the election of chairperson is more than one, a poll shall be taken by secret ballot. Now 7 says, if poll is to be taken, officer appointed by the deputy commissioner shall assign symbol to each contesting candidates, and the decision of the state officer in the allotment of symbols shall be final. Immediately after allotment of symbols, the officer appointed by the deputy commissioner shall announce the names of the contesting candidates on the basis of list of contesting candidates prepared by him in Form 27, and a copy of the said list of contesting candidates along with symbols shall be supplied to each other. Now, if for any reason we assume that now because of the dispute going on inside the party, these persons, they do not want any nomination, one of them will be chosen.
Just a moment.
My lord.
In the copy of the act supplied to me,
My lord.
Please come to page 2. Definition of returning officer.
Page 2, my lord. Yes. Returning officer means an officer appointed under subsection 2 of section 105 and includes an assistant returning officer appointed under subsection 3 of the section 105 for performing any function.
In this act, we only have section 80, last page 19.
In this act, my lord.
Page 90, we have section 80.
Page 90, yes, my lord.
Something is wrong.
My lord, yeah. 90, act number, yeah. More 90.
Just give me act.
My lord, yes. Page 90. Your lordship is referring to page 90, my lord.
Yes, the last provision is section 80.
Act clause.
But this
80.
2L.
Yes, my lord,
2L,
yes, yes,
2L,
yes.
2L says section 105.
My lord, this is the rules, my lord. Conduct of election rules, 2001.
So
this is not the act. Act is of 1997, my lord. In the act, your lordship will find the relevant provision for election of chairperson is section 88(2), my lord. Section 88, subsection 2.
So you see, the returning officer is not the deputy commissioner. It cannot be. It must be read as returning officer under 2L, which will make it appointable under 105 by the state election commissioner.
My lord, that is for the election to the various officers of the Jila Parishad or Gram Panchayat. We are now for the election of the chairperson of Jila Parishad from amongst the members of Jila Parishad and within the meaning of Rule 67, my lord.
Okay.
It is different.
There the words are deputy commissioner.
My lord, that is my submission, my lord. And my lord, since your lordship has just now taken the act, lordship may just have a look at the provisions of section 88 for a moment, my lord. Section 88 of the 97 Act, my lord.
Yes.
88 subsection 2 says, my lord, as soon as may be, after a Jila Parishad is constituted, the Jila Parishad shall elect in the prescribed manner from amongst its members a chairperson who shall, subject to other provisions of the Act, hold office for a period of 5 years with effect from such date as may be notified by the government. So, procedure is in Rule 67. Now, my lord, what has happened after this hurried process was undertaken, we submitted our representation, which your lordship will find at page 31 of my repetition, my lord. Just one page. May I read this, ma'am? Page 31, ma'am.
Yes.
Prayer for halting of election process of Jila Parishad chairperson.
Yes.
This is regarding the body of the letter.
Just tell in short what is this. Just tell in short what is this instead of reading.
My lord, this representation we submitted just to inform that you are doing it in a hurried manner. All subsequent days are holidays for different purposes, my lord, Eid ul Fitr, etc., Saturday, Sunday. So kindly do not do it in a hurried manner, number one. And my lord, we have also pointed out about the order passed by the Honorable Supreme Court, and that no notice is given, all these things, my lord. Now, this representation has been disposed of by, since it was addressed to the Deputy Commissioner is disposed of by order, my lord. Page 33. Order dated 2nd of April. And citing the violation of natural justice in the 3rd paragraph, my lord, it has been mentioned, whereas this infirmity in the due process can render it infructuous. Therefore, the process of election of Jila Parishad chairperson is now held in abeyance till further notification after due consultation with all relevant stakeholders. This was the order passed by the Deputy Commissioner. So the whole process was kept in abeyance. Now, madam, this representation that has been disposed of by this is of 2nd of April. I'm sorry, madam, this is 1st of April from District President. Now, page 34, lordship will find the ADC, who is the returning officer, he again disposes of another representation saying that no, everything is dismissed. Page 34, my lord. This is very interesting.
Yes.
Lordship will kindly permit me to read this, but this is important. We have essay in this order also. Whereas the letter of BJP party dated 1/4/2025 was received via WhatsApp seeking halting of selection of Jila Parishad chairperson dated so basing on the claim that 28 March 2025 date of election notification is a national holiday and that it was served hurriedly and the matter having been sub judice. Whereas notification for ZPC election was made on 28 March of 2025. Therefore, the claim of BJP party that 28 March 2025 is a national holiday is not valid as it doesn't fall under gazetted notification of holidays in the Arunachal Pradesh. Hence, the claims are not justified. Whereas the notification was served in person and through electronic media to all the 6 ZPM and of KEIP in your district. Therefore, the claims that it was not served to them properly and hurriedly is not justified. Then whereas the claims that the matter is sub judice and cannot be proceeded is also not justified as legal opinion of the Advocate General was taken for the conduct of JPC election because DC KEIP had asked for legal opinion to Advocate General of Arunachal Pradesh through his letter dated 19th of March 2025. With reference to that, Advocate General AP has given his legal opinion via letter number so, wherein he has positively suggested to conduct the ZPC election as per the Arunachal Pradesh Panchayat Raj Conduct of Election Rules 2001. Whereas 5 ZPM had served a legal letter for conduct of election as per the notification by so dated 20th March 2025 to Deputy Commissioner to cancel his order dated 2/4/2025. Whereas Deputy Commissioner has instructed in the same letter to the member of secretary, returning officer to consider the demands of JPMs and to process accordingly with the election process as per schedule notification. In view of above, the claims of Tanya Tajing, BJP President KE Paniyar and Sri Zoram LU ZPM 3 HOL application dated so is dismissed and disposed of accordingly, and order number so dated so is hereby pronounced infractuous. So the order number 2425.
Deputy Commissioner. Deputy Commissioner.
Deputy Commissioner's order, my lord, is now held infractuous by a subordinate officer. Deputy Commissioner.
224, page 33.
No, number 2 is not right.
Yes.
So my submission with your lordship is, first, the whole process of initiating the process of election of chairperson of the Jila Parishad is without any authority of law, because it has been initiated by the ADC in the capacity of a returning officer. There is no appointment of any returning officer. Deputy Commissioner has not appointed anybody as a returning officer. ADC under the rules doesn't have any power. So it is the Deputy Commissioner who is authorized by law to initiate the process. That being the position, my lord, the very notification is without any authority of law and therefore it should be quashed. And if that is quashed, my lord, the entire process will go. Secondly, my lord, no notice was given in such a hurried manner it is done. And thirdly, my lord, when your member as a Jila Parishad, your membership as a Jila Parishad has already been under challenge and Deputy Commissioner has disqualified. The Honorable Supreme Court has only granted a stay, but the matter is still sub judice. The process of appointing a chairperson, electing a chairperson in a hurried manner shows that they are flouting all the relevant laws and hurriedly they want to appoint one of the 4 persons to be a chairperson. And the party never nominated, whereas the Rule 67 provides for nomination by the nomination.
Second part of the submission is difficult to accept when the Supreme Court has stated the disqualification. It can't be said that he is not a member of the Jila Parishad. And if he's a member, he can stand for appointment.
My lord, the notification lordship will find notification I am challenging also on the ground that on the same day nomination, scrutiny, withdrawal, and then date of poll on the next day, and the counting is on a date.
How many Jila Parishad members are there?
6, my lord, altogether. After bifurcation, my lord, 6 of the original Jila Parishad fall in the newly created Jila Parishad, my lord.
Okay.
Now, my lord, my third submission will be, my lord, I am apprehending that my learned friend appearing for the respondents may raise a point that the writ petition itself is not maintainable. He has not, of course, till now said anything, but I am just, if necessary, I'll make elaborate submission. But straightway I say that this writ petition will not be barred in view of the judgment of the Madam Mohinder Singh Gill or Ponnuswamy or subsequent judgments, for the simple reason that the remedy which the law provides in an election dispute cannot be had in a proceeding of present nature, because for that, well, I'm just referring to, Lordship, may kindly have the rules once again, my lord.
Just take a short break and come back.
Mal. Any of the following corrupt practices, namely, an election offense as mentioned in subrule 1 above, any payment to any person or whomsoever on account of any conveyance of an elector to or from any place for the purpose of casting his vote. 3, hiring, employment, borrowing, or using any vehicle for the purpose of conveyance of any elector to or from any place to the polling station or the purpose of casting his vote, provided that any elector may hire the conveyance or use his convenience vehicle for conveying himself to or from the polling station, or the result of election has been materially affected by any irregularity in respect of the nomination paper or by the improper acceptance or refusal of nomination paper or in voting or by any non-compliance with the provisions of the act or the rules made thereunder, the election of such candidates shall be declared as void, provided that if the election tribunal is of the opinion that any corrupt practice has been specified in sub-rule 2 of this rule, which does not amount to any form of bribery other than treating as hereinafter explained as has been committed, and if the election tribunal is further of the opinion that the candidate has satisfied that no corrupt practice was committed in such election by the candidate, and that any corrupt practices committed contrary to the orders and without the sanction or the connivance of such candidate, and such candidate took reasonable means for preventing the commission of corrupt practices at such election, and the corrupt practices committed were trivial nature, not affecting the election materially, and in all other respects, the election was free from any corrupt practice on the part of the candidate or any of his agents, then the election tribunal may declare that the election of such candidate is not void. Then explanation is there. At the conclusion of the inquiry, election tribunal shall declare whether election of the internal candidate or candidate is void under Rule 73.
This election of chairperson under the this Arunachal Pradesh Panchayati Raj Act is under which section?
Section 88, my lord. 82, yeah. Section 88, subsection 2, man.
Yes, okay. Yes.
So that being the position, my
You wanted to say something more, Mr.
Well, I'll just sum up that 5 points I have raised. I'll just sum up my in one line, so that it becomes convenient for my learned friend to respond. Number 1 point I have raised is ADC has no power under section 67, rule 67, to issue notification of 28th March. This is number 1, my lord. Number 2, ADC, by passing the speaking order, the ADC has rendered the order passed by the deputy commissioner, who is higher in rank, as infructuous. So that power he doesn't have. This rather amounts to insubordination, my lord. So this speaking order is therefore bad. Thirdly, my lord, no notice of this election was given to any person, and which is evident from the keeping abeyance order passed by the deputy commissioner saying that there will be violation of the principle of natural justice. Then fourth is
I don't get it. Please repeat again. Number 3, what you are saying?
My lord, number 3, I'm saying that no notice of this election of chairperson was issued to the members, which is evident from the fact that the deputy commissioner, while passing the order on 2nd of April to keep the entire process in abeyance, specifically mentioned that there will be a violation of principle of natural justice if we go ahead with this election process. Fourthly, my lord, counting in terms of the initial notification of 20th March is to take place on 3rd of March without any subsequent amendment or corrigendum. Counting cannot be held on any date after 3rd of March. It is not a, my lord, small thing. And fifthly, my lord, the issue raised in the writ petition cannot be raised by way of a writ petition, so there is no question of any alternative remedy being available to the writ petitioner. And therefore, if any plea is taken about any existence of any alternative remedy, I'll elaborate, but this is my submission. That being the position, my lord, I pray that the whole process should be stayed at this stage as an interim measure, and after hearing the parties, the initial notification and the speaking order should be set aside and quashed. That's all, my lord. If anything is required, I'll just.
Yes, Mr. Tiwari.
Yeah, my lord, I will answer by one. Total 5 points have been raised. To begin with, before I answer all these 5 points, my lord, in brief, the present situation is elections were duly held, Form 26 issued, and respondent 4 has been declared elected. This is the final situation. I'll come to that later, now one by one. First of all, ADC has no power under Rule 67. For a moment, my lord may turn to Section 88, subsection 1 of the Panchayati Raj Act. Section 88, subsection 1. Now, Section 88, subsection 1 of the Panchayati Raj Act says the additional deputy commissioner shall be the member secretary of the Jila Parishad. Whether my lord has got it?
Yes.
The additional deputy commissioner shall be the member secretary of the Jila Parishad. Section 88, subsection 1, it's a substantive provision. Now, Section 88, subsection 2 says, as soon as may be is very vital. As soon as may be. After a Jila Parishad is constituted, the Jila Parishad shall, in the prescribed manner, from amongst the member, a chairperson who shall, subject to the other provisions of the Act, held office for a period of 5 years, with effect from such date as may be notified by the government. So, Jila Parishad has to be constituted as soon as possible. After Parishad is formed, the chairperson has to be elected as soon as possible. In this case, my lord, the Jila Parishad was formed on 7th of June 2024. 7th June 2024, Jila Parishad was formed. Because of disqualification proceeding, orders of the Honorable Court, matter going to the Supreme Court, the chairperson could not be elected. So the mandate of subsection 2 was required to be followed. So, my lord, the member secretary, it is the additional deputy commissioner who shall be the member secretary. And now member secretary, my lord, is competent to hold the election. So far as, my lord, the deputy commissioner is concerned,
yes.
So far as the deputy commissioner is concerned, my lord, the deputy commissioner played both the sides in this case, trying to play very safe. When the representation came from the Bharatiya Janata Party, deputy commissioner said it's an abeyance. But in the same order, if my lord will call for the original records, in the same order, the deputy commissioner also referred the matter to the member secretary, saying that, look, the Jila Parishad members have also submitted a representation. So you act accordingly. The election process should be looked into and continued. So my lord played both the sides. Deputy commissioner then referred the matter to the member secretary. In any case, my lord, the deputy commissioner doesn't have the competence to stop the election. Now, so far as, my lord, the entire procedure is concerned, that is point number 3, my lord, the speaking order itself at page 34 of the writ petition gives the complete picture. Lordship, again, I will read the speaking order. Page 34 of the writ petition. Whereas letter of BJP party dated 1st April 25 was received via WhatsApp seeking halting of selection of Jila Parishad chairperson dated 2nd of April 25, basing on the claim that 28th March 25 date of election notification is a national holiday and that it was served hurriedly and the matter having sub judice. Whereas notification for ZPC election was made by number such and such dated actually 28th March. Therefore, the claim of BJP party that 28th March 25 is a national holiday is not valid, as it doesn't fall under Gazette notification of holidays in Arunachal Pradesh. Hence, the claims are not justified. Then, whereas the notification was served in person and through electronic medium to all the 6 Jila Parishad. So, my lord, there is no reason not to believe this. It was served to all the 6 members. Out of 6, my lord, petitioner is the only one who's disgruntled. The remaining 5 are on the other side. The majority is with us. The democratic process has been followed. whereas the notification was served in person and through electronic medium to all the 6 Jila Parishad member of KE Penyor district. Therefore, the claims that it was not served to them properly and hurried is not justified. Whereas the claim that the matter is sub judice and cannot proceed is also not justified, as legal opinion of such and such was taken, etc., etc. Legal opinion, naturally, my lord, it is subsection 2, mandate is very clear, as soon as maybe number 1 and then shall. How long, my lord, the chairperson, the Jila Parishad can continue without the chairperson? How long Jila Parishad can remain dysfunctional? Because if the chairperson is not there, my lord, there will be no functioning of the Jila Parishad. So therefore, my lord, again I read from this portion, was taken for conduct of JPC election because DC KE Penyor had asked for legal opinion to Advocate General of Arunachal Pradesh through letter number such and such, dated such and such. With reference to that, Advocate General had given his legal opinion, etc. He has positively suggested to conduct, etc., etc. Whereas the 5 Jila Parishad member had served a letter for conduct of election as per the notification such and such, dated 28 March 25 to Deputy Commissioner to cancel his order such and such. Whereas Deputy Commissioner has instructed, this is important, whereas Deputy Commissioner has instructed in the same letter to the member secretary cum returning officer to consider the demand of ZPMs and to process accordingly with the election process as per scheduled notification. So, my lord, if it is argued that Deputy Commissioner kept the election in abeyance, how could the member secretary continue the process? The reason is this. Original records may be called for, we can look into that. In view of above, the claim of such and such, and she such and such application is dismissed and etc. So, my lord, this is what it is. And since, my lord, the majority is, all the members are on one side, the 4, my lord, the 4 Jila Parishad members unanimously elected the respondent 4. Out of 6, my lord, 5 on one side, petitioner is on the other side. The outcome, my lord, is absolutely logical. Even now, if the elections are held, the petitioner has no chance. The majority is not with the petitioner. So, my lord, my submission would be the mandate of section 88 subsection 1 would override whatever is there in the rules. Rules, after all, are the creature of the substantive provision, not otherwise. And then, my lord, so far as 122 is concerned, section 122. Since elections are complete, respondent 4 is duly elected, Form 26 has been issued. My lord, my learned friend is there. Mr. Tashi may give the papers to your lordship because Form 26 declaration is also there. Copy was sent to me. Those documents can be placed before your lordship.
You are referring to section 1. You are referring to section 122.
Yes, my lord, 122. Lordship may see the last page, the Form 26, the declaration also. Form 26 is the last page. Prior to that is the message of returning officer, 2nd of April. That's the mail that the respondent 4 has been elected uncontested. Because majority is with us. Why majority? All other members are with us. There was only one nomination. The respondent 4 was the only person. And 4 are supporting him. So, my lord, entire process is followed. And 122 is a clear bar. 122, lordship may see, 122 subsection 3A Roman 3. 122 subsection 3A Roman 3. Any other election matter in such manner as may be prescribed. Constitution of Election Tribunal. The government shall constitute election tribunal consisting of one of the member to be appointed by the government to dispose of all election petitions challenging elections to a panchayat, matters relating to disqualification of a member of the panchayat, and 3, any other election matter. So, my lord, any other is widely worded. Any other election matter. And this is election. Respondent 4 is duly elected.
In such manner as it may be prescribed.
Yes, my lord.
What according to you is the prescribed manner for election of chairman?
My lord, there, my lord, I'm sorry, my lord. So, I beg your pardon.
No, this 123(3), clause
Lord.
3 says, A3 says, any other election matter in such manner as may be prescribed. So what is the prescription?
Prescription, that is, my lord, this of the election tribunal, how election tribunal will deal with the election petitions, the procedure of that. It is the power of the election tribunal. The procedure followed by the election tribunal to dispose of the election petitions. So therefore, my lord, what I submit is, apparently, my lord, ADC is a competent authority. ADC is a member secretary. Member secretary is competent. And my lord, all said and done, election process is complete. Respondent 4 is declared elected. Election petition lies. And this is, my lord, certainly because so far as interim order is concerned, my lord, the balance of convenience is certainly not in the favor of the petitioner. And there is no question of irreparable loss. And where is the prima facie case, my lord? Certainly, it can't be said that my election is a nullity. Since June 24, my lord, the parishad is dysfunctional. It can't function without the chairperson. No meeting is being held.
You have not responded to section 67, which is referred to by Mr.
My lord, my submission is this: whatever is there in 67, 67 has to be harmoniously construed with the mandate of section 88, subsection 1. Because 88, subsection 1 says additional deputy commissioner shall be the member secretary of the Jila Parishad. So if additional deputy commissioner shall be the member secretary of the Jila Parishad, ultimately it is the member secretary's competence. Member secretary has to initiate the process.
Is the minutes of the proceedings available? No.
Yes, my lord, minutes of the proceedings are also available. It is not annexed with the writ petition, but the minutes of the proceedings are there. Second of April 2025, I hope that in the pile of papers which has been given to my lord, this minutes are there in the second page. Lordship may have a look.
No.
I don't know. One scanned copy has come to me sitting here. It is the minutes only. I don't know what has been handed over to my lord. Minutes are there. The first page is the notification of election. The second page in my compilation is the minute, dated 2nd of April 25. Whether my lord has got it? Then I read, my lord, the majority ZPM present, yes, the majority Jila Parishad members present are requesting for conducting of election-wide application dated 2nd April 25 as per the schedule. Since there is no reason to postpone it, DC has also instructed to consider the representation and proceed accordingly, and also telephonically called Sri Zoram Elu, ZPM 3 Achuli, and also telephonically called Zoram Elu, I think that is a petitioner, and apprised him about the election of ZPC. He was also served election notification in person, equally important. They are talking about not being given any notice. Therefore, the election proceeding was conducted peacefully. There was only one nomination for Jila Parishad chairperson post proposed to Srimati Likha Sang Chore, ZPM such and such, by Nili Likha Tabo. And there was no other nomination or proposer for the post of Jila Parishad chairperson. Proceeding was done on the basis of legal opinion of such and such, Advocate General White such and such. and letter of Deputy Commissioner White such and such dated actually 19th March 25 and election notification White number such and such dated actually 28th March 2025. In view of above, on the basis of voice vote, Srimati Dika Sang Chori is declared uncontested as ZPC 27K tenure on this 2nd of April 2025. So, my lord, my submission is when there is only one nomination, all others are supporting respondent 4. It can't be ballot for the sake of it. Democratic principle, my lord, is the essence of any election. And over here, my lord, out of 6 Jila Parishad members, the 4 members are supporting the respondent 4. Only one disgruntled member is there. So, my lord, leaving aside everything, even if we take into consideration the very democratic principle, the democratic spirit, this election is perfectly in order. Only on technicalities, my lord, this democratic principle is sought to be sabotaged by the writ petitioner. Finally, my lord, whatever my lord has to see is to see whether the democratic principle has been upheld or not in the present case. It has been upheld. Respondent 4 is the choice of the majority. So, my lord, I answer one by one. The first submission that it is the ADC who is the competent authority under the rule 67 is not correct. It is the Deputy Commissioner who is the competent authority under rule 67 is not correct. Finally, it is the mandate of section 88 subsection 1 which has to be seen and looked into. 88 subsection 1 being a substantive provision of law, and rule 67 has to be harmoniously construed with the scope of section 88 subsection 1. That's the first point I'm making. Secondly, ADC acted in subordination of Deputy Commissioner.
Which rule you are referring to? Which rule you are referring to? 67?
Rule 67. Rule 67 has to be read in harmony with the mandate of section 88 of the Panchayati Raj Act, especially subsection 1 and 2. Subsection 1 clearly says additional Deputy Commissioner shall be the member secretary, shall be. The moment you are ADC, you are also the member secretary of the Jila Parishad. So this is below the point number 1, answer to the point number 1 raised by Mr. Mazumdar. Secondly, the second submission of Mr. Mazumdar is ADC acted in subordination of Deputy Commissioner. My lord, from records we find this is not correct. The Deputy Commissioner on the one hand kept everything in abeyance, but at the same time, in the same order, as per the records, Deputy Commissioner also instructed the member secretary to go ahead with the electoral process and to look into the representation of Jila Parishad members and examine it. Accordingly, my lord, the member secretary acted accordingly. So there is no question of insubordination. Deputy Commissioner was acting very smartly in the present case, not getting into any controversy. So this is the answer to the second submission. The third submission is no notice was given. Now, my lord, whom do we believe? Do we believe the writ petitioner or we believe the materials available on record? The due notice was given. This is the answer to submission number 3. The fourth submission is counting was not done on 3rd of March. The answer is what is the rationale behind the counting? When there is one nomination and all other members are supporting respondent 4, the democratic principles are being upheld in the present case. This is the answer to submission number 4. And the fifth submission is that, well, there is no, so far as alternative remedy is concerned, alternative remedy is neither effective nor it is needed in the present case. My submission is this is not correct. The mandate of section 122 is very clear. It is any other electoral matter. Election is complete. Respondent number 4 has been declared elected. Form 26 is there, already been issued. And my lord, the election of respondent number 4 is beyond the scope of the writ petition. My lord may have a look at the prayer made in the writ petition. In the writ petition, election of respondent number 4 is not under challenge. Form 26 is not under challenge. It is only the notification which is under challenge and the electoral process. So, my lord, my submission is writ petition as on today is rendered infructuous. If at all they are aggrieved, they should file election petition before the election tribunal under section 122 of the Panchayati Raj Act. And finally, my lord, again I will reiterate, here is a case where substantively, overwhelmingly, the democratic principles have been followed. It is evident and apparent that all the members of Jila Parishad are in favor of respondent 4. The writ petitioner is the only one left out, who's disgruntled. And my lord, the entire idea is to sabotage. They do not want elections to be held. They are waiting for the judgment of the Supreme Court. As and when that comes, if 4 members are disqualified, then the ground will be clear for them. They want that situation to come. That is why, my lord, since June 2024, the Jila Parishad was dysfunctional. So therefore, my lord, in the facts and circumstances of the case, no illegality has been committed whatsoever. And the writ petition, my lord, therefore, is liable to be dismissed. That's my submission.
Yes.
May I give a quick response to the reply given by my learned friend? My first submission is that if the phrase as soon as may be appearing in section 88 subsection 1 of 1997 Act is to be treated as overriding the provisions of Rule 67, this will amount to amending the rules, number 1. Number 2, my lord, this will go directly against the principle that if a statute, my lord, your lordship is aware of that, my lord, Nazir Ahmed's case ratio. If the statute provides a manner of doing a particular thing, it has to be done in that manner and all other manners are excluded. So it is good for me that my learned friend has admitted that Deputy Commissioner doesn't have power. According to him, it is the member secretary, the ADC being the secretary, and considering the fact that as soon as maybe the chairperson is to be elected, he intervened and he has taken the power. When the rule, the act, do not give such power to the ADC or the member secretary, he cannot on his own usurp the power given by the act and the rules to the Deputy Commissioner and go ahead, because if DC is keeping neutral, ADC is taking side. It is absolutely clear. DC is keeping neutral, but ADC is taking side. The Lord will kindly consider. Secondly, my lord, my learned friend has read the impugned order, speaking order, to say that Deputy Commissioner himself has referred it to the member secretary. My lord, Deputy Commissioner might have referred to consider certain things, but Deputy Commissioner never said that you pass an order which will have an overriding effect over the order which I have passed, saying that I'm keeping the entire process of election in abeyance. So therefore, the order part, the speaking order is an order without any authority. He cannot pass an order setting aside or, my lord, rendering infructuous an order passed by superior authority. He doesn't have the power. Statute and the rule has not given any power to him. And my lord, member secretary, who is member secretary? Member secretary doesn't have any power under the rules. Assuming that in the absence of anybody, any speaker and a deputy commissioner having not initiated any step, he is keeping maintaining neutrality, then member secretary doesn't get, for that matter, any power. There are ways and means to ensure that as soon as it is done. And my lord, so far as the submission that I can go through for an election petition, my lord, as I have submitted, my lord, this notification under 28th of March 2025 cannot be challenged in an election petition for the simple reason that the tribunal constituted under section 122 of the Act doesn't have the power to set aside an order passed by the competent authority to hold election. And whether it is issued by a competent authority or not, it is not within the jurisdiction of the election tribunal. My lord, your lordship is aware of that judgment of Mohinder Singh Gill. There in paragraph 33, possibly, my lord, that judgment, I'll ask my learned friend to. Section 30, my lord, the whole judgment in starting from Punnuswamy to Mohinder Singh Gill, that in such matters, election petition is the only remedy, and writ petition will not lie because alternative remedy is available. The whole law has been settled on the ground that you have got an alternative remedy and you cannot adopt another remedy which is not available to you. And para 33 of this Mohinder Singh Gill, our conclusion is not a matter of text. Kindly see para 33, my lord. Whether it is telling, it should tell you no. My lord, para 33 starting with the words our conclusion, my lord. As your lordship got, my lord.
The difficulty with SCC is that it doesn't match.
Whereas the paragraph starting with our conclusion is not a matter. It will be near about para 33, my lord. It is SCC. Well, I have taken from SCC only, para 33, my lord. I am reading from para SCC, my lord.
Yes. No, some other judgment you provided. Union Territory of Ladakh. You provided me Union Territory of Ladakh.
Yes, I'll come to that, my lord, but I'm just reading para 33 first for a different reason, my lord.
Mohinder Singh Gill is not provided.
My lord, I'm just reading 2 lines. I'll just provide this. Para 33 reads like this, my lord. Our conclusion is not a matter of textual interpretation only, but a substantial assurance of justice by reading section 100 of the Act. Act means RP Act. Your lordship is aware of that. As covering the whole basket of grievances of the candidates. So the whole basis of that judgment is that you have a remedy available under section 100. Now, here is a case where my submission is, I do not have any remedy to challenge the initial notification of 28th of March through this my lord, election petition before the election tribunal. And so far as this judgment is concerned, my lord, 2023 SCC online SC 1140. My lord, facts I'll not read much, but just to say that this was a case where, my lord, writ petition was already pending. My lord, may I kindly have a look at para 4, my lord. This judgment of Ladakh, my lord. 2023 SCC online SC 1140. Para 4, my lord.
Yes.
The controversy involved in this list is the non-allocation of the plow symbol to the writ petitioner, the Jammu Kashmir National Conference, response number 1 herein referred to as R1, for its candidates to contest the then upcoming general elections of the Ladakh Autonomous Hill Council, Kargil. In view of the urgency in the matter, the learned single judge passed an interim order on 9/8/2023. The operative portion thereof at paragraph 11 reads as under. Keeping in view that upcoming general election of Ladakh Autonomous Council and Development Council stands announced, the petitioner party is directed to approach the office of the respondent number 1 and 3 and 5 for notifying the reserved symbol plow already allotted to it, and response 1 to 3 and 5 shall notify the symbol allotted to the petitioner party in terms of paragraph 10 and 10A of the election symbol reservation of allotment order 1968, and allow the candidate set up by the petitioner party to contest on the reserved election symbol plow already allotted to the party. This was the interim order passed by the writ petitioner entertaining the minor writ petition by the single judge of the High Court. Thereafter, writ appeal was preferred, and since no relief they got, they approached the Honorable Supreme Court. Then Lordship may kindly see para 36 and 37, my lord. this availability of alternative remedy was discussed in these two paragraphs. We are conscious, my lordship has got my para 36.
Yes.
We are conscious that by way of certain pronouncements, some of which are alluded to in this judgment, the court extended principles relating to elections to parliament, state assemblies, and municipalities to other arenas as well. Indicatively, the interpretation of judgment is always to be made with due regard to the facts and circumstances of the peculiar case concerned. We have looked at Article 243 O, 243 Z, G, and to 329 of the Constitution, and conclude that no bar hit the High Court even on principle. Apart from the judgments expressed, considered, and dealt with hearing before and hearing after, we have perused out of our own volition the decisions internally bearing bench judgment of the Supreme Court in NP Punnaswamy. I mean, all this Mohinder Singh, etc., all has been referred and discussed. Then para 37. We would indicate that restraint self-imposed by the courts as a general principle laid out in some detail in some of the decisions, supra, in election matters, to the extent that once a notification is issued and the election process starts, the constitutional courts under normal circumstances are loath to interfere, is not a contentious issue, but where issues crop up indicating unjust executive action or an attempt to disturb a level playing field between candidates and or political parties with no justifiable or intelligible basis, the constitutional courts are required, nay, they are duty-bound to step in. The reason that the courts have usually maintained a hands-off approach is with the sole solitary objective of ensuring that the elections, which are a manifestation of the will of the people, are taken to their logical conclusion without delay or dilution thereof. In the context of providing appropriate succor to the aggrieved litigant at the appropriate time, the learned single judge acted rightly. In all fairness, we must note that learned AG during the course of arguments did not contest the power per se of the High Court to issue the directions. It did, except that same amounted to denying the appellants their discretion. As stated here above, we are satisfied that in view of so-and-so, the appellant discretion was not unbridled. And accordingly, my lord, this SLP was dismissed, which your lords will find in para 44. For the reasons stated aforesaid, the entire election process initiated pursuant to notification dated 2/8/23 issued by the Administration of Union Territory of Ladakh, Election Department, so-and-so, stands set aside. A fresh notification shall be issued. And this is my prayer in this case. I am challenging the initial notification itself. I am not challenging the, my lord, subsequent election of the respondent number 4 as chairperson. I am on the very basis of the initiation of the process of electing the chairperson by issuing that notification by an incompetent authority, and when the law prescribes specifically that it is the deputy commissioner who is to initiate, who is to fix the date, who is the appoint the person who will pronounce. Nothing has been followed here in this case. The reasons are very clear. And my learned friend has very clearly submitted that democratic principle has been followed here. I'll say, my lord, the democratic principles have been given a very clear go by here by not allowing the party, you, my lord, and these are the 4 persons who have sought, who have been fighting, who are before the Supreme Court to establish that they still belong to the BJP party, which is a national party. Now they are now acting in such a manner that they are not allowing the party to nominate a person to be elected as the chairperson. This is the democratic principle they are following. So that being the position, my lord, the entire election in this case is absolutely without any legal sanction, and the whole thing has been initiated on the basis of a notification issued by an incompetent officer who has got no authority under the law, and therefore the entire election is vitiated, and this remedy is not available by the I'm deeply obliged. My.
Please button up your coat.
Sorry, sir.
Button up your coat.
Sorry.
Button up your coat first.
Okay, I'm sorry.
Yes.
Sorry, sir. This is a writ petition, sir. And this is filed for defreezing of the bank account of the petitioner number 1 and petitioner number 2. Sir, my account has been freeze unlawfully and unjustifiably on the direction of respondent number 3 and 2 by respondent number 4 and 5. 2 and 3 are the investigation agencies and 4 and 5 are the bank. Sir,
We can only
this,
issue notice at this stage.
please, sir.
We can only issue notice at this stage. We issue notice.
Yes.
Judge. Your name?
Anand Dugal.
A.K. Dugal, heard Mr. A.K. Dugal and counsel for the petitioner. Next, freezing of the bank account of the petitioner. On the account of which is 1 or 2?
Sir, sorry, sir.
Account of which petitioner is seized, 1 or
Both.
petitioners?
1 and 2 both.
Officers have been. Accounts of the petitioners have been frozen by petitioners operating in the HDFC Bank within bracket respondent 5 upon directions by the respondent number 2 and 3 is sailed in this writ petition filed under Article 226 of the Constitution of India. Next one. Notice. Return number on give a date after 4 weeks. Return going to also. Mr. N. Luang, Leonard, Senior Government Advocate, accepts notice for all the respondents. So, accordingly, to visit extra copies of the writ petition, be served on. No, he'll appear for 1. The account is in which, whose account is in which bank?
Petitioner number 1 bank account is in ICICI and petitioner number 2 bank account is in HDFC Bank.
Petition number 1 account is in ICICI within respondent number 4 and 2 is HDFC Bank respondent number 5. Mr. Luang accepts notice on behalf of respondent numbers 1, 2 and 3.
1, 2 and 3.
We visit extra copies served on me within 2 days. In course of the day, make it in course of the day. Petitioner shall take steps for within 2 days for service of notice on the respondent numbers 4 and 5 by registered post with AD. So, the counsel for the petitioner is at liberty to collect the postal receipt number from the registry and submit postal track report prior to the next date of listing. Next paragraph. The affidavit of decision, if any, by the respondent numbers 1, 2, and 3 shall be filed at least 1 day prior to the next date of listing. List on 13/5/2025. No, 13 is a Tuesday. No, make it 14. 14/5.
Can it be in a shorter date? So because the 250 employees are working in my company and I'm holding a PWD contract and developing the sports university. My problem is that I have to give the salary to the employees and the vendors also. And the amount which is mentioned in the FIR the case property account amount, that is the whole project amount with even the, not even a single bill has been raised yet. And this is what the conduct of respondent number 3 is. Only the disputed amount with respondent number 1 is 1 crore rupees. And he has made the seize of 101 crore rupees. That is the whole project amount.
Where is that? Where you said that?
May kindly see the FIR, sir, page number. Yes, sir. That is page number 23. Serial number 10. Total value of the property 101 crore 45 lakhs. And may kindly see the complaint of the complainant. That is on page number 21. What he is claiming. That is on para number 14 of the complaint, page number 21. After several months of unfulfilled promise and attempt to reach them, we have been unable to recover 2 crore rupees, 2 crore 6 lakh rupees. That was fraudulently taken from us under the guise of non-existence project. This is the amount and this is the conduct of the investigation officer. 250 employees are suffering. Multiple litigation are coming in between. And vendors, they are raising the bill every single day. And it's a very big project. I received petitioner number received from the government of India, PWD. And the total value of the project is 101. May kindly take a seize up to maybe till next date, may log 20680 with the complainant is claiming.
Okay. Just add there before receiving the submissions. Referring to the FIR, based on which the operation of accounts has been seized, am I to submitted that the purported financial claim by the complainant is to the extent of where is the amount? Which page? Which was that page?
Sir, page number 23 of FIR, page, serial number 10.
It was rupees 2,06, 80, 886.
Sorry.
However, the respondent number 3 where is your bank statement?
Sir, my bank statement. Sir, there is 2 impugn action taken by the bank, which is placed on page number 112 and 113, annexure 15, sir.
No,
This
no,
is
not that.
this is the request from me,
see,
and this is the conduct.
We don't know, not about the conduct.
Yes, sir.
Conduct is that they only frozen the bank operation.
Right,
How
sir.
much amount was there in the bank? You're not disclosing.
Sir, we because the bank has already been freeze, so thereby we are.
You see, you may have 1,000 rupees in your bank account.
Right, sir.
How do you suffer?
I may kindly impose up to the claim of the claimant because the money is there, obviously.
We don't know. You,
Yes,
you are
sir.
alleging that for 2 crore rupees they have stopped 100 crore.
Right,
100
sir.
crore is not stopped. It is the only your bank account which has been frozen.
That I have to get the figure from my client.
Okay.
Or in the meantime, you may kindly put the restriction up to the amount which the
No,
claimant is.
We don't even have an interim prayer here.
Please, sir.
Even interim prayer is not made here.
Yes, sir. I
Okay, make it 5th, returnable on 5th. No, don't write that. Okay.
Fifth of, no, fifth, right, sir. Obliged, sir.
Lordship, impugn order is page 32, Lordship.
Page
Page 32, Lordship.
32.
32. Annexure 5, Lordship. May I, Lordship, just a brief background before coming to the impugn order, Lordship.
This would not be maintainable. This IA is in title appeal.
In title appeal, Lordship.
Oh, acha. Okay.
In the title appeal, it is. Lordship, just I'm challenging this very order on 2 count, Lordship. May I read, Lordship? The impugn order. Otherwise, Lordship may continue as 2, Lordship.
Yes.
Lordship, may I proceed or at 2, Lordship?
Okay. Good. Acha. This is wrong to register. You request the, you ask the registry to correct it. This is Article 227. So it will be registered as CRP, IO.
Malad, I'm sorry, Malad.
No, you just write it, mother. This the petitioner is assailed. The order passed by civil court in connection with an interlocutory application in appeal. And the application is, and the present application is preferred under Article 226, right, with Article 227 of the Constitution of India. Order challenging, order under challenge being a civil court order. The registry shall re-register this application as CRP IO and place it for it.
See, otherwise, Lordship, I have a citation, Lordship, where even 226 and 227 both will lie, Lordship.
It will not lie. It will not lie. You'll please read here 1967. Just kindly note. Naresh Sridhar Mirajkar, year 1967, Supreme Court 1.
Malad.
It's a judgment by 9-judge bench.
Lordship. Here, Lordship, yes, a judgment. There, Lordship, what it has been held, Lordship. If there's a violation,
No judgment can override a 9-judge bench judgment in Mirajkar.
No, in that judgment also, Lordship, there's a violation of the principle of natural justice, Lordship.
Still 226 will not lie. That's why I say. I'm very clear.
Malad. I'm sorry, Malad. Item number 6, Malad. Here I am instructed to withdraw the matter because the petitioner.
9 and
Item number 6, Malad.
6 and 9.
6, Malad.
6.
6, only 6.
Only 6. Okay. Mr. Kato.
My
Who is the
lord,
respondent?
with
here?
the liberty to, with the liberty to, my lord.
Mr. With liberty.
He is
Okay.
no longer.
Mr. Ram, you are there. Ram for the state respondent.
Lordship, that will be listed,
No, it will be today, it will come.
Today,
I
okay.
told him.
Fabulous, my lord. My lord, in this case, as per the, my lord, the notice that the 25/11/2024, my lord, the tender process was completed on 6 January 2025. This tender, subject matter of the tender was, my lord, PDS Rice Land Road Carriage Contractor. So thereafter, my lord, the result has not been declared till today. Therefore, my lord, on 24/3/2025, my lord, I have ventilated my grievances before the concerned authority, that is the Deputy Commissioner Eastern District, my lord, that the result should be finalized. Therefore, I am here before the lordship with a limited period.
As per the verbal instruction, Lordship, they are within 1 month, they'll dispose the representation of the, and they are trying to award the tender or contract also, Your Lordship.
Okay. Mr. C. Modin and counsel for the petitioner. Also heard. Mr. Y. Ram, the senior government advocate, agreeing for respondents. Next, please. In brief, the case of the petitioner is that he had participated in the tender process. Not he, the petitioner society had participated in the tender process dated 6/1/2025 for
PDS Rice Land
this.
Road Carriage Contractor.
Tender for NFSA TDS Rice Land Route Carriage Contractor. In your synopsis, you say 6/1. Where is that 6/1 tender?
My lord, 6/1 is the, my lord, date of tender process. Thereafter, my lord,
Where do I find that date? Your tender is 17/12.
17/12, Your Lordship.
Issued on 17/12/2024.
Your Lordship, 6/1 is the date of opening of tender. It's,
Date of opening is something else, but
yes,
tender process is not 6/1.
yes, Your Lordship.
Stated that they said tender was opened on 6/1/2025. So, however, the tender has not been finalized till date. So, however, as an interim measure, the And by ad hoc appointments, some carriage contractors are allowed to transport the PDS rice. Accordingly, the petitioners claims to have submitted. I don't know, Mr. Modi, if you write like this, I will not be able to do anything. In your synopsis, first you write that the representation was submitted on 24/3. After 2 lines, you said that if the representation dated 25/3. Now, what is right?
My lord, they should be 24/3, my lord. Clerical mistake, my lord. They should be
No,
24.
no clerical mistake. You don't have time to read it after drafting.
24/3, 2024.
2025, which is also not attended to. Hence this writ petition. This writ petition has been filed under Article 226 of the Constitution of India. Next paragraph. The learned government advocate has submitted that he has received oral instructions that the Deputy Commissioner from Pasighar within bracket respondent 2 has informed that the said tender would be finalized within a month. Next problem. Said submission. What is of the considered opinion that it will be appropriate to close this writ petition by directing the Deputy Commissioner from Pasighar within bracket respondent 2 dispose of the representation of the petitioner dated 24/3/2025 within a period of 1 month from the date of receipt of certified copy of this order, along with a full copy of the writ petition. Writ petition shall dispose over the motion stage. Directions as indicated above. Certified copy with the copy of writ petition.
Well. Outline.
My lordship. Lordship, in this case, to go by, before going by this interlocutory application, lordship, we have to understand the case by the petition, main petition, lordship. The issue is simple, lordship. There was my uncle has given me a gift, a land in the form of gift. That was forwarded by the competent authority for transfer. And accordingly, government has approved the transfer. It was just 180 square meter. And accordingly, the the director land management has issued a communication letter for transfer of land in my favor. But when matter was given to the DC Poland, Deputy Commissioner concerned, DC, what they did is they inconsistent report saying that there is no 180 square meter. I cannot, we can just provide you a 160 square meter. Whereas that land is, since 2015, matter has been, we are continuously paying this land revenue and all the formalities. Land is under my occupation of my previous this landowner, and that was supposed to be transferred in my favor. That is the case. And now, when I visited to DC Poland, some illegal construction is going on nearby, adjacent to my side. That is why, at the influence of that person, DC Poland is giving inconsistent report, saying that you cannot be allotted. We can reduce the size of your land. That is the issue.
But how a writ petition would be maintainable for that?
Yes, maintainable, since Deputy
Tell us
Commissioner,
why.
Deputy Commissioner is.
Then why we have civil court to, and you see somebody is occupying a land. You don't want to file a suit against them. You don't want to file any eviction case against them in an appropriate court. You come to a writ court, say that my LPC be implemented. You see, let us take an example where you purchase a plot of land by a sale deed. Now, when you purchase the land from a sale deed, you find that the entire land is occupied by some settlers. Can you come to a writ court and say that I have a sale deed, please implement my sale deed?
Lordship, in that case, I'm saying that the non-compliance of the order of the government, Lordship, this is the issue here. Whereas government has given the order in my favor, then who is the Deputy Commissioner at DC to not to comply the order? That is, I am seeking mandamus, Lordship.
By mandamus, you want eviction.
Yes.
Is it permissible?
I just wanted 180 square meter.
Is it permissible in law? Any authority on the point that by writ petition, people can be evicted?
Lordship, it is.
Who is to be evicted? Can it, have you impeded him?
Lordship, just I have visited here, somebody is constructing Mr. That is in my this IA, one Tanijana.
No, I'm asking
Yes,
you whether he is a party here.
Not party. I just wanted.
Okay, please tell me.
I just wanted.
Please. No, it's okay. I'm just asking you. You see, many things I don't know. I'm just asking you. In such cases,
yes,
is the principle of natural justice denied to those persons against whom LPC will be implemented? Don't they have a right to be heard?
I'm seeking what has been allotted already, Lordship. Not against somebody, because land belongs to me, Lordship, by way of transfer.
Okay.
Land belongs to me, Lordship. Not against somebody else. Land is on 30 years lease already, as per the policy.
Any provision that if any law enforce that once an LPC is granted.
Not LPC, Lordship. This is land allotment, Lordship.
Okay, land allotment.
Allotment.
Any law enforce that when a land allotment letter is given, the Deputy Commissioner has a bounden duty to have to hand over a clear land to the allotted person.
Lordship, apart from discharging the role of the Deputy Commissioner, he is having the district.
First of all, whether there is a law or there is no law.
He is the district land record officer, Lordship. He is supposed to maintain the record, Lordship. That is his bounded duty. He has to maintain, since he is, we are regularly renewing this, paying the land revenue. Lordship.
In this state, is there any eviction law available?
I suppose, Lordship, Deputy Commissioner has a duty to, Lordship, maintain the land record, Lordship. Since land is in my possession by way of lease, this gift deed.
Yes.
And that has been already approved in my favor by the competent authority.
Where is the law relating to this land allotment? Under which provision of law?
It's in Arunachal Pradesh Land Records Act, Your Lordship.
Land Records Act. Which is that provision?
Provision is title over the land, that is there, and under the, as per the section 12.
12, Your Lordship.
Allotment of government for agriculture and housing purpose. The rule alignment. That is the act.
Where is your land document? Where is your land document?
Then documents is lordship in the main petition lordship. Kindly see, previous landowner is page number 34, passbook number 30, page number 24, read petition.
Yes.
Annexure 3 of the read petition lordship. There is a passbook issued to this previous owner.
Where is your gift deed? Where is your gift deed? Where is the gift deed by your uncle?
Give deed.
Gift deed.
Duty.
Gift.
Gift deed is lordship, page number 30. 30, annexure 4.
You don't have to register a sale deed here? Gift deed?
It's a gift deed. Yes, we have to register now.
Is this correct? Page 30? This is signed by judicial magistrate.
Judicial magistrate. For that, I need instruction for that, Your Lordship.
Where will you find this registration act is adopted in the state? Registration Act, 1908.
Yes, Your Lordship.
Yes.
Yes.
Where will I find that? Adopting Act? Volume 1? No.
No, Your Lordship.
Volume 2. Yes. Thank you. Thank you, Mr. Tapin. I appreciate. Mr. Tapin, I am unable to follow this because this doesn't say about adaptation in Arunachal Pradesh.
Lordship, these are the list of, Lordship, the act,
List of acts which has been adopted by the state.
state of Arunachal Pradesh.
Okay. But it is in a very unusual.
Lordship, that is,
Not with-
that is a lordship.
Okay. Registration Act is mentioned here. Chronological list of pre-constitutions which has been extended Arunachal as on 1/1/1981.
Okay. Because pre-constitution, all these are the pre-constitution.
Okay. Mr. Tapak, you have read this give deed, whether it is lawful or not, we are not commenting right now. Have you read this give deed? Does it contain that you were handed over the possession of the land?
Donor is the relatives lordship.
No, that's okay. You see, my father has had so many things when he was alive.
No.
I was his only son.
Yes.
I was not allowed to touch most of his things. I was very afraid to touch things of my father. Only son.
In respect of, to my understanding lordship, in case of government land, since it is a government land can be transferred at the permission of the government only. Because land belongs to government.
Okay.
This is the, to my understanding, it is the law. It is as per the land allotment order, it is 30 years lease to the applicant. And that can be transferred at the permission of the government. Since it has been transferred and the competent authorities approved and communicated. And it is the bounded duty of the deputy commissioner concerned to the public, discharge the public duty.
Where is the LPC you said?
Land allotment
order? Where
not
is that?
LPC. LPC is land possession certificate. It is a
Where is
land
the
allotment.
Order? Yes, where is
In
that?
case of allotment, it is land belongs to government.
Allotment order is not there.
If
No,
it
you
is-
just said that you had a land allotment and therefore deputy commissioner is bound to do it. Few moments back you said
if
that you
land
had
is-
the land allotment letter.
LPC is generally private land. This is a government land.
So in government land, you want eviction.
I wanted to have 180, get it transfer, 180 square meter, not eviction.
I'm sorry, I'm confused.
No.
You said the government land cannot be transferred.
Yes, government land.
And this land is a government land and you got it by a gift deed.
Gift it.
Gift deed is not a transfer according to you.
It is a transfer. That can be at the permission of the, I am saying it is at the permission of the government that can be transferred.
Okay, so where is that permission?
Competent, since competent authority has already approved, that is a
Where is
transfer.
it? Where is it?
Can you see this page number, communication letter, can you see?
Yes, yes.
Page number annexure 7, page number 36 of the WP.
36.
Yes. May I read the operative portion also. In this communication letter, letter has been written to the deputy commissioner by the director land management. The language is so. I am to refer your letter number such and such to convey the approval of the competent authority for transfer of the government land, subject to the payment of the annual lease rent of the remaining lease period as fixed by the government from time to time, and the process fee of processing 5 rupees per square meter and other terms and conditions of allotment will remain unchanged. Details of the approval is given below. Former one is Takitatin and the present one is Ojingdaron, this petitioner. And area approved is 100 square meter. This purpose is for commercial purpose. Plot number 30. it implied that competent authority has already approved. That is a formal land allot order may be issued in the last line from your end by cancelling the earlier government order. Competent authority has given direction to the deputy commissioner concerned to cancel the previous owner, and in that place, the petitioner name may be reflected.
Okay. Yes, Mr. Bassett, what do you say?
Lordship. There is no provision for transfer, your lordship, under. Until now, your lordship, no transfer has been done and he's,
Mrs. Bassett, you have gone through the documents here, no?
lordship,
Have you read the documents annexed here?
yes, lordship,
You've gone?
yes.
Perhaps no. Perhaps no. It doesn't help you to say yes. Please come to page 42. Second last paragraph, page 42. The shortfall is hardly 14.5 meter length, 1.5 meter breadth, which can be easily acquired by carving out an area of only 20 square meter
Yes.
from adjacent vacant government plot of more than 500 square meter, still remaining unallotted, though under unauthorized occupation.
Yes.
It is ridiculous that the land management grant is not exploring such available alternatives to meet up the shortfall in the land area from the adjacent vacant land of the government.
Yes. I've gone through it, lordship.
You've gone through it
Yes.
now or earlier? Now. Okay, I'll pass orders in the chambers. What is this IA for?
This is for, I'm just securing 180 meter because this there is, when yesterday, day before yesterday, when I visited to my land, and someone was constructing illegal building over there, but the DC was not taking any action, because if any construction RCC, but the Pakka building construction is there. If RCC building is
Where's your
construction, then I
statement?
will be.
Where is your statement in your petition?
Kindly see in the page number 6.
Page number 6.
Yes,
Yes.
exactly page number 4 of annexure, page number 4,
Yes.
paragraph 4.
Yes.
Statement. During the
Your pendency of the case, one Sri
once in-
Kani Jiran.
yes,
Is he a respondent here?
not respondent. Yeah, yesterday. That only.
The person has no government land allotted despite so and so.
Just inside.
Then is it to be implemented? This is deficient, allotted is not captured, might be captured.
Yes,
Where is the construction of house you are referring to right now? We are arguing that house is being constructed.
he's claiming my part of the land.
Claim and you see, you made certain statement. I am just asking you where it is pleaded.
Because Lordship, day before yesterday, I went there. That is why I came to know some application has to
No, that's
be filed
okay.
there.
You see,
He's illegal occupant there. He's
I
capturing
understand,
the
but I
government.
can't record your name as a material exhibit.
Yes.
I can't say I have heard it from Mr. Rapak and therefore I.
But
make a-
we are claiming no relief against this Mr. Tanijera because we want DC to secure 180 square meter only. Since land belongs to government. And he is that is why. It is just a factual statement saying that something is going on here.
I don't know, Mr. Tapak, your submissions are very inconsistent. Come to para 9, you say that you are not claiming any relief.
Para 9.
Page 9, your
Page-
interim prayer. Can the password is in chambers? This.
Appropriate order may be passed.
Maybe the lawsuit. Item number 21 to 33 are similar matters when we have filed impleadment application. Where we have filed impleadment application for impleading the applicant as respondent number 8, Oil India Limited. The lawsuit will take up.
You are for the petitioner.
I'm for the petition.
Any objection?
No.
Allow this application.
Yes, Lordship.
Mr. Riham, I just forgot to record. In item number 3, who was representing the government? I forgot.
Mr.
Is it Tapin was
Item
there?
3.
Okay, I forgot to have written yes.
See.
No,
Oh, Lordship.
I did not record the
Oh,
your
Lordship.
presence, so therefore I suddenly realized.
Lordship.
No,
I am
did not
for
record
2
your
and
name.
3, Lordship.
2 and 3.
2 and 3.
But 3 is by name.
4 is I think by name.
No, 4 is a private, is the
4 is the private respondent.
private respondent.
2 and 3 is one is the deputy commissioner, other one is the
No,
member secretary.
I think it is by name.
The 4 is by name also.
3 is by name also.
Okay, I think
Just check up. That's why I. No, petition, he'll have to see the petition. No, it's okay, I'll send it across. Yeah, इसके पास होगा, Champa के पास. Just wait for some time.
No, sir.
Because. Heard. It's a Sharma. No, it will go for, no, it's in typing. I've given dictation. इसमें से प्रिंट आउट निकाल
is here.
Huh?
I'm for 2 and 3. 4 is by name and 1 is.
No, 3 is, who is 3?
3 is the member secretary.
Oh, acha, member secretary. Okay. Then I am mistaken. Okay. Mr. A. Sharma, done counsel for the applicant. Also heard Mr. D.K. Deuri, learned counsel for the opposite party. Who is the petitioner in the connected petition? Next one. It is projected in this application that the connected writ petition was filed challenging the eviction order passed by the jurisdictional divisional forest officer And this court, while issuing notice of motion, directed maintenance of status quo. Next, the case of the applicant is that in connection with the said land, petroleum mining lease has been issued in favor of the applicant.
Yes, your lordship.
And therefore, the and therefore the learned counsel for the applicant has submitted that if the matter is heard and disposed of in his absence, the applicant may suffer irreparable loss and injury. Accordingly, it is submitted that the applicant desires that the matter be heard in his presence, in the applicant's presence. Next paragraph. The Mr. Deori.
No, I'm not objecting.
Our operations are now stalled because of this status.
I have a different reason to ask. Correct. These are professional things.
Yes.
You must always consider that.
Correct, your lordship.
Next, for the learned counsel for the opposite party.
We are not party.
No, you are not. No, Professor Deori. The learned counsel for the opposite party does not object to the prayer made. Next, accordingly, this application stands allowed, and the applicant is permitted to be included in the connected writ petition as respondent number
8.
8 in all these cases.
Yes, your lordship.
8. In the writ petitions, you say here Mr. D.K. Devri will be petitioner. Heard Mr. D.K. Devri and counsel for the petitioner. Also heard. So those petitions are listed today. Yes. Also heard Mr. Vaidiram, Daniel, government advocate appearing for all the respondents. Also heard Mr. A. Sharma. No, I don't write his presence right now. Next, by order passed today in the connected writ petition, I connect an interlocutory application. The Oil India Limited is represented by Mr. H. Sharma and Council. It's permitted to be Oil India Limited is allowed to be included as respondent number 8 in this writ petition. Next paragraph. Mr. A. Sharma, Learned Counsel for the newly implicated respondent number 8 is present. Next paragraph. The Learned Counsel for the petitioner shall provide a copy of the writ petition to the Learned Counsel for the newly implicated respondent. Next paragraph. No formal order is passed for issuing notice on respondent number 8 as they have implemented themselves. However, liberty is granted to the respondent number 8 to file their affidavit in opposition, if any, within just 2 days prior to the legislative listing. Next, the order of status quo is granted earlier, continues to further orders. Next, list on.
Date fixed.
Here interim is there, like.
Sure, you extended it.
In one matter that came up recently, it was fixed on 15th of May.
15.
Let that be fixed along with that, but.
Yes, lordship.
15/5/2025.
Yes, your lordship. Regarding the amendment of the cost title, is it necessary, lordship?
Oh, Asha, right. You are right.
Yes.
Next one. Before that,
In between some.
the Learned Counsel for the petitioner shall provide freshly typed out copy of the amended cost title, including respondent number 8
Yes.
to the deputy registrar with the judiciary within 2 days. So as to
Within 2
incorporate the
days,
same.
it will be possible from tomorrow, it's vacations.
No, 2 days means always working day. Saturday, Sunday,
Yes.
holidays are covered by
Reopening we can do it.
exclusion or limitation.
2 days will be like 10 days for him now.
Huh?
2 days will be like 10 days for him now
Two
because of
working
this.
days, make it 2 working days. Okay.
Two working days with them.
Two
like
working
this.
days.
Otherwise, they will take it other way around.
But you're right, we have done it, but under limitation, those days, holidays are excluded.
Yes.
So as to incorporate the same in the writ petition.
Only the cost title need to be amended.
Yes. The cost title, the old cost title will be replaced by the new one. That is the High Court rule.
That particular page has to be changed.
Only page need to be
Only
changed
that
on the
page.
last page.
Okay.
Oblige.
Yes.
Losip, before coming to the Losip impugn order, yes, I'd like to brief the background of the present case, Losip. Losip, here the two stories are here, Losip.
Where is the order of injunction? Initial order of the trial court? Where is that?
Order is at page Losip, impugn order is page 32, Losip.
This page 27 is the first order.
This is the Keva order, Losip,
This is a cable.
by the village authority, which has been Losip stay by page 32, Losip,
Page 32.
which is the impugn order before this Losip.
Where is the High Court order of 2/9/2024? Where is that?
Losip, that is it page 22, Losip.
32.
Here, page 22, Losip. And present respondent was the petitioner, Losip, the revision petitioner. They sought for Losip, remanding it back to the village authority to decide the appraised Losip. Now, Losip, the petitioner, present respondent is taking in other way, Losip. Now there is sitting the Losip, village authority has no jurisdiction because it has been already Losip decided in favor of the present respondent by the learned court below, then learned session district court, then by this court, and by the Supreme Court Losip. And that very particular judgment passed in suit number 19 of 2017. That was between the present respondent and another lady Losip, Pechimenya. And if Losip is the impugn order, the principle.
In the Keba, who was the first party?
In Keba Losip, the present respondent, me and present respondent, and two another person Losip.
No, it was a complaint. Who was the complainant?
I am the complainant.
You are the complainant.
I am the complainant. Before the Keba.
This Keba decision.
Losip.
Was against you.
The Keva decision is not exactly against me, Losip.
Okay.
It's rather against the present respondent.
Against the respondent.
Present respondent, Losip.
But okay, present respondent. Okay.
Present respondent.
Who is the in page 32? Who is the appellant?
Losip,
Tucker.
page 32.
I am done.
He is the appellant and the applicant in the IA.
Okay. So this was allowed.
Yes, this IA was taken up on that very day. Even it was not in the coast list, Losip. This IA was not in the coast list, and it was taken up on that day without giving us opportunity of raising any objection, Losip. The matter has been disposed of, Losip, allowing the Losip stay of the Keba order passed by the village authority, Losip. Now I'm questioning.
For that you are referring to page 34.
Page 34 is the Losip title suit, Losip. If Losip, before coming to page 34, if Losip take up the page 36, Losip.
30?
36. 36. This is the cost list of the, for that particular day, that is the 21st March 2025 lawsuit.
Yes.
Lawsuit will find at serial number 10.
Serial number 10.
10.
Title appeal.
This is the title appeal 9 of 2024, which is still pending before the learned court below, filed by the present respondent.
Okay.
This particular title suit has been listed, which was supposed to be listed in the 14th of May, as per the order dated 12th of March lawsuit.
Where is that?
Lawsuit, the present respondent filed appeal lawsuit. Appeal was heard on 12. Kindly come to page 34 lawsuit.
30?
34.
34.
34. Lawsuit will
Yes.
find down below the first hearing done on 12/3/2025. This is regarding the appeal lawsuit.
Yes.
And next date of hearing was 14/5/2025, which is yet to come lawsuit in the month of May. It's about the lawsuit that title appeal number 9 of 2024 lawsuit. It was taken up on 12. Lawsuit.
Information kiosk is available outside.
This is in the portal, is available in a portal lawsuit.
Where is that portal?
Portal district court, some portal is there lawsuit.
Just show me.
Registry that I don't have it with me lawsuit. And it has been downloaded from that very portal only lawsuit.
The portal and revenue. Case management is done. Civil court. मेरे को ये इसका प्रिंटआउट चाहिए रजिस्टर ये चाहिए You have a copy of this page 34 with you?
34 I'm with is with me lawsuit.
No, but if you have a spare copy.
Lawsuit, this was done through my staff lawsuit. I got it downloaded through my staff lawsuit. So basically.
No, you have an extra photocopy of that document.
Extra copy lawsuit.
I just need an extra copy.
The password.
इसका वो चाहिए इसका रिकॉर्ड नहीं इसकी चाहिए इनका दिन से Yes.
And more one information.
Is it correct that matter was what you call preponed and taken up?
Yes, my lord, matter was taken up, but there was some error in the post list that was informed to the board of council during before the hearing of the case, and hearing was conducted after due consent from the both parties as a last item. My lord, here the petitioner also contest the case. Even their submission has been recorded.
Then we'll have to interfere with this order. The entire process is wrong. You come to page 32. This has to be state.
My lord, 22.
Page 32. Learned Counsel Diribai has filed Wakalatnama to represent respondent in both the main title appeal and IA. Copy of IA is served to the Learned Counsel for the respondent.
Yes, sir.
That is on 21 you serve it. And on 21 you dispose it off. The court disposes it off.
Yes, my lord.
Where is the objection?
My lord, the petitioner not object the petition, and they go for.
You see, in a civil proceeding, you have a CPC with you. You have CPC with you.
Yes.
Civil Procedure Code. Please look at section 141 of the CPC. The procedure is read.
Miscellaneous proceeding. The procedure provided in this court in regard to the suit shall be followed as far as it can be made applicable in all proceeding in any
Suit.
court of civil jurisdiction.
Or civil jurisdiction. So transfer on objection has to be given. Can I justify because let us say I am the trial judge. You are available in court, I give you a copy of the plaint. And then I start dictating the judgment on the ground that you were given the copy of plaint, but you did not seek an adjournment for filing of objection. Can I start dictating a judgment?
My lord, because this order was because there is a execution order. Execution proceeding. Before
Whatever
the
is there is there.
that my lord, that executing proceeding is in final stage. And that execution suit was filed after the filing of appeal number 9. My lord, I want to relate one judgment. My lord, relevant portion is page number 486, paragraph, second part of paragraph 486. And the second line, I would like to relate the second line. I'm married.
Yes.
But the judicial approach required that during the pendency of appeal, the operation of an order having serious civil consequence must be suspended. More so when appeal is admitted. My lord, in this case, appeal was admitted. And this, my lord, this interim order is only for time being. This is an interim order, not a final order, my lord.
But this application has been disposed of.
Well, I was disposed. However, the order is in interim. My lord, may kindly see the page number 33. 33, third para. May I read, my lord?
Yes.
Hard borderland council seen the record, considering that the civil court, Court of Civil Justice, Senior Division UFIA will deciding the title suit number such and such passed by decree in favor of the appellant and granted right title and interest in his favor to the suit land, and same was upheld before the Honorable District Judge UFIA, the Honorable High Court, and affirmed by the Honorable Supreme Court. And despite that, the head Gabura Model Village Nahalagan passed an order dated 14/11/2024 in connection to disputed land of 980 square meter, and considering that in connection related execution application number such and such is filed before EAC Nahalagan and related notice is issued by EAC Nahalagan. This court is of opinion, considered opinion that sufficient cause is made out to grant stay on order dated 14/11/2024 passed by the head Gabura Model Village Nahalagan till the pendency of instant appeal. Till the only this order is passed only for till the pendency of appeal. Appeal will be heard on 14th of the May. This is only interim order, my lord. Otherwise, this stay order was not passed. The execution proceeding has been disposed by passing a serious adverse order to the respondent, my lord. My lord, appeal has been admitted. Appeal filed by the respondent has been admitted. During the pendency of the appeal, the execution has to be stayed. Therefore, by exercising the power under order 41.
Where is the execution petition and what is the order, Mr. Tapin? In the execution petition, what is the order passed?
Lordship, that order is exactly not here, Lordship. But in the education proceeding.
What is page 65?
In education proceeding, Lordship.
What is page 65?
This is the Lordship.
Is this the execution petition?
No, Lordship. Yes, this is in education petition. But here, Lordship, he has been asked to show cause, Lordship. Down below, Lordship. He has been asked to appear on this particular date and to show cause why education should not be granted, Lordship.
Yes.
And even he has not even filed reply also, Lordship. Till now, Lordship.
My lord, may kindly see page number 67, my lord.
You see, still this order is wrong. 60. Okay. It's a money decree.
Lordship, he has been directed to refund back me the sale price with
money decree.
My lord,
in title suit, this order has been passed, Lordship, by the Blaze Authority.
this is neither money decree, neither that title decree.
Why?
My lord, the order of the head Gabura. A respondent has been directed to give another land, either land or money.
Where is that? Land or money, that's why.
Yes.
Land you are not giving. This page 65 is only money decree then.
My lord, page number 31, my lord. Order passed by the page number 30. Last paragraph. My lord.
You see, up to order 41, rule 1 of the CPC. Order 41, rule 1 CPC.
Yes, my lord.
You're reading which provision?
An appeal shall not be offered as stay of proceeding under a decree or order appeal from except so far as the.
No, no. This is not order 41, rule 1.
Form of appeal.
Yes, after that, come to 3.
3 months. Where the appeal is against a decree for payment of money, the appellant shall within such time as appellate court may allow deposit the amount disputed in the appeal or furnish security in respect thereof as court may deem fit.
So the court could not be stated without requiring security under section under this 1(3). Without security to dispose it of is not good. So it has to go back.
My lord, because my lord, this judgment is even there is no decree. This is a judgment. In judgment, there is no specific that money has to be paid. However, my lord,
This is the order of the what you call the customary court.
my lord, however, being aggrieved of this judgment, I have filed appeal within a limitation period.
This question of limitation doesn't come. This doesn't say about limitation or not. 41 rule 1 is a condition precedent. Order 41 rule 1 is a condition precedent. There can't be a waiver in money decree. So it is for this ground it has to go back. We'll not disturb the stay, but we'll ask the court to give you liberty because it's an execution. Stay to vacate the stay will cause injustice. Then the entire amount may be recovered, even if he has a case. But we still remand the matter back, maintain the order of stay, and say that the court will give you an opportunity to move the court for seeking security. This provision for security is.
Lordship, may I propose, Lordship? This order, I'm basically questioning this order, Lordship. One is, Lordship, I have not been given opportunity of hearing, Lordship. Second is that, Lordship, on the pace
No,
of
that's okay.
on the pace of the records, Lordship.
So Mr. Sapin will tell you. When it is order 41 rule 5,
Lordship.
it is just between the court and the appellant.
Lordship.
Since the stay cannot be granted otherwise, by operation of order 41 rule 5, the appellate court has power to stay. And that is not subservient to any objection of any kind.
Lordship.
This one. But yes, you have a right. You could have availed the right under Rule 6. Order 41 Rule 6 is security in order of execution of a decree appealed from.
Lordship.
And for deposit of some amount as required under Order 41 Rule 1(3). It is for this purpose that we are sending this matter back. Stay will have to continue. Once there is a judgment, decree which has been admitted in appeal.
But on the pace of the order, Lordship. The principle of res judicata has
That's
been
why-
applied,
that's why,
which does not exist at all, Lordship.
No, I was visiting it as order 39 for stay,
Lordship.
but this is order 41. In 41, I don't have to hear the other side. It is for the court to record its satisfaction. So there's no impropriety.
Lordship. But
So
while issuing the interim order, Lordship, order is saying.
No, but you see, that's what we are trying to get it. We are not getting it right now. You see, what happens is that let us say that execution is going on.
Lordship.
You are the defendant, judgment debtor, you don't know about it.
Lordship.
Now suddenly you come to know that within some time the execution will take place. And you rush to court with order 41 rule 5. Correct.
Lordship.
The appellant comes to court.
Lordship.
You are an appellant here now. You come to court that, okay, by half an hour my building will be broken. Please stay.
Lordship.
So at that stage, I don't have to ask anyone. It is for the court to record its satisfaction whether I should grant an injunction or not. Stay. Correct.
That's correct, Lordship.
So therefore, we don't find any fault with order 41 rule 5.
Lordship.
But yes, you have a right to move the court under to object it for the purpose of order 41 rule 6
Lordship.
and order 41 rule 13, so that the court can either give you some make a direction for pre-deposit
Lordship.
or ask for security. It's only a money degree.
My lord,
Otherwise, Lordship may remand it back, Lordship, to the learned court below.
You're showing us what document that this is not a decree?
my lord, this is a judgment, not a decree, my lord. Even
Correct.
even my lord,
Can a customary court grant a decree, make a decree? No.
my lord, CPC said that judgment cannot be executed.
That will not apply in a customary court. They don't have records. They are not given the customary courts is the court, civil court of a lowest form.
Now, my lord, in Arunachal Pradesh Civil Code Act, there is a provision that other than the customary court, the civil court act has to be applied, my lord.
Yes.
Here the education
But
is,
customary courts do not have, you see, they don't have a court master, they don't have any facility. How will the uneducated, what you call, customary court officer, whoever he may be, he may come on Gambura, how will he prepare a decree?
my lord, it is the under CPC, so. My lord,
No, you
apart
see,
from that,
the bar should have moved the court for clarifications of these things. These are, you see, the problem is that if we take over everything, then this customary court system will fall. It will not stand.
my lord, apart from that, my lord, in customary court, before the Gaubura has not afford me to produce witness. Even my written
Those
statement.
things, that's you see that is in your appeal. But the fact remains that there is a money decree. You have to pay you have to give land or you have to give money. Once there is a money decree which has been sent for execution, that means he is not asking for land any longer. When it is for money, then when you come for appeal, security is something which you can't avoid. It has to go back.
Lordship, otherwise, irony is that, Lordship, this IA where impugn order has been passed itself, he has invoked the order 41 rule 5. Now he is submitting that, Lordship, it's not a decree, it's a judgment, Lordship. Anyway, Lordship, may I pray, Lordship, it may be remanded back and liberty may be given to make any other legal submission objections, if any, permissible under the CPC. That observation and matter be fixed on particular date. I think till then education is not listed. It has been rather adjourned.
Stay will continue.
Well, execution is in at final stage, my lord. Execution is in final stage. Well, can you see page number 67?
Whatever.
Yeah, but they continue to say.
The stay is continuing. Whether it is final or not doesn't matter.
And learned court below may be directed to pass a praise order, Lordship, after hearing me on all the
Heard.
laws.
Mr. S. Impleadment counsel for the petitioner.
Till then, interim may be continued. Thank you.
Also heard, Mr. Your name?
Yes, sir.
O Modi, madam.
O.
Modi.
Modi, learned counsel for the respondent. Next paragraph. So, this application is made under Article 226, read with. Yes, we have got it, but this doesn't appear to be improper.
Yes.
Same thing which you have downloaded, the same thing. We have a different format. In the portal, it is reflecting that it was listed on 12th.
Laws.
So that means like this matter. No, the present rate petition, present CRP which we are taking up.
Lawsuit.
In the morning, it was registered as a rate petition.
Yes, yes, correct.
Correct. I passed an order. Now it is listed as a CRP. That has been taken up.
Yes.
So now when Mr. Modi wants, he can't complain that the procedure was not followed. It was registered in a different nomenclature. We rectified the mistake. I passed an order. On passing of the order, this order has been done. So you've seen this. I have passed the order.
Lawsuit.
Correct. After this order, the registry has changed the nomenclature. Now it is now listed as CRP. Correct. So once it is there in the portal, that means formalities are completed.
Lawsuit.
So the propriety is not there. Today CGM is closed.
No.
Today CGM is closed.
Yes,
yes, ma'am. Close, I think.
Huh?
Today, I think CGM is closed today.
Today's proceeding.
Today is closed. CGM is closed.
It seems closed. It seems. Office must be open.
I don't know. Although this application has been registered under Article 226, read with Article 227 of the Constitution of India, however, as writ cannot be issued on a civil court, this application is treated only as one under Article 227 of the Constitution of India. Next one. By this application under Article 227 of the Constitution of India, the petitioner has assailed the order dated 21/3/2025, passed by the learned civil judge within bracket senior division, bracket close UPR, in IA number 20 of 2025. Next paragraph. The grievance of the petitioner is that the proceedings of Title Appeal number 9 of 2024 was registered on 13/12/2024, and the matter was next taken up on 12/3/2025. Correct. That is the first date. 12/3 is the first date.
The past order lawsuit.
First date is when 12/3.
12/3.
12/3/2025.
And
the next date of the matter was fixed on 14/5/2025. So, however, the proceedings of title appeal number 9 of 2024 was preponed and taken up on 12/3/2025, and on the said date, an interlocutory application, which was registered as IA number 20 or 25 was registered and taken up. Which was filed under the provisions of Order 41 Rule 5 CPC. Full stop. The further grievance of the petitioner is that without granting any opportunity to the petitioner to contest the said application, the court, in the learned court in exercise of jurisdiction under Order 41 Rule 5 CPC had stayed the proceedings of execution application number 4 of 2025, which is filed before the EAC, Naharlagun. Till the pendency of the said title appeal number 9 of 2024, next page. Yes, correct. Insofar as the procedural part is concerned, from the portal of e-courts, e-court India services, small court, next is India, next word services. This is there. Now it is seen that the corrected appeal so that title appeal, not connected, title appeal number
9 of 24.
9 of 20 or 2025.
24 also. 24. Title appeal is 9 of 2024. Yes.
9 of 24. Yes, 9 of 2024 was preponed to preponed and taken up on 21/3/2025. Due to the filing of the interlocutory application being IA number 20 of 2025. And accordingly, as per order dated 21/3/2025, the case record was put up in view of the said IA. Next paragraph. Therefore, as there was an impending execution The entertaining of the interlocutory application by the learned civil judge within bracket civil senior division bracket plus UPR cannot be faulted with. Next point. However, in the considered opinion of the court, the petitioners put the decree to execution and it appears from the documents appended to this interlocutory application that the execution is for realization of a sum of rupees. Where is that page? I saw that. Where is that page? Execution lawsuit.
Is 65 laws.
Page
65.
65. Page from the docs.
Last order at page number 67.
67.
After 17.
What is the WPC 90? Who is what?
90 is the lordship one because that title appeal filed by the present respondent. It was filed in the month of December 2024 lawsuit, and London CGM was not taking up that matter. So they filed this writ petition before the Sonoma Court with a prayer to direct the London Court below to take up the appeal lawsuit.
That will not be maintainable. Writ petition against the court is not maintainable. You have seen that judgment, Mirajkar?
I have seen lawsuit just after lawsuit has passed the order. Just I was thought of lawsuit placing this judgment. This is a Suryadev Rai case.
No, Mirajkar. Mirajkar is 1967.
This judgment also has been referred. The 9 judge.
It doesn't. That part is not written here.
It has been considered in this lawsuit. How it has been interpreted. Lawsuit see the paragraph 16 to 21. Because in that particular judgment, that was the lawsuit judgment passed by the
Suryadev Rai. You see, Suryadev Rai is already overruled.
Lawsuit. Then I'm in wrong side lawsuit.
Suryadev Rai is already overruled.
Then lawsuit, I'm
yes, it's mentioned here. That part is written here. In paragraph 18, there's a mention here that the High Court cannot issue writ to another High Court, not by bench of the High Court, or to a different bench, must as the certiorari. No, this is certiorari, not that. Writ cannot be issued on a civil court. In this Supreme today, which I use, from 37 onwards, it's a discussion on power of the court to issue writ. Order can only be corrected by issuance of certiorari or in appeal or revision, whatever is permissible. Article 19 is not violated by an order of the court. No certiorari against order of a competent court, judicial order of court in exercise of Indian jurisdiction is to help administration and justice. And therefore, it's very clear. No writ against a civil court.
Yeah, because of this Suyadev Rai's case, Lordship, I was little.
No, Suryadev Rai merely says it doesn't record the entire judgment of this Mirajkar. Mirajkar judgment year 1967 SC 1.
Here, some interpretation has been given.
It's okay.
Because
but
in that particular case, Lordship, dear Lordship, the order was passed by the Honorable High Court, exercising the original jurisdictions. So therefore, writ cannot lie against the order passed by the Honorable High Court, Lordship. That was the facts behind this Naresh Sridhar's case, Lordship. And it has been distinguished in that manner, Lordship. Now, so for the other courts, Lordship, below the Honorable High Court.
So therefore, 227 is permissible, but
That-
Suryadev Rai is overruled
Okay.
by a 3-judge bench. Suryadev Rai is, I'll just tell you. This is Radhesham versus Chabinath.
Radhesham
versus Chabinath.
Chabinath.
This is by 3-judge bench and reported in 2015.
18.
15. 5 SCC 423.
5 SCC
423. And this, in this judgment, para 11 and 12, is again made clear. You see from 11, and here they are referring to another 7-judge bench. And then they refer to the 9-judge bench.
Nine
Viraj Kar. Just look at this. That's why this overrules Suryadev Rai on that point. 11 and 12. Where I stopped, just say that after that. Stop. However, comma. Under the facts and circumstances of the case, comma, as it apparently appears from the, it expressly appears from the documents on record that the execution proceeding, which is currently stated to be pending before the Court of SS, the Extra Assistant Commissioner, Itanagar Capital Complex, is for recovery of either land measuring an area of 980 square meter or to refund back a sum of rupees 24,50,000 with interest of 4% aggregating to a sum of rupees 33,32,000. Essentially the decree would also be for recovery of money. Therefore, the applicant, the petitioner, may be well advised to move the learned Court of Civil Judge within Senior Division, Practical UPR, under the appropriate provisions of law for claiming secure pre-deposit of deposit of a part of the decretal amount or for security in such manner as the petitioner will be so advised. Thanks, Pranav. Accordingly, the stay of the disposal of the IA number 20 or 2025 shall not be a bar for the petitioner to move the trial court in an appropriate manner as the petitioners may be so advised. Just observations are indicative of this petition stands closed. We are giving you an opportunity to move the trial court in an appropriate application and for security or for deposit of money. And this did I say that the disposal of the IA 20 should not be a bar? I said no. And this disposal of this will not be a bar for you to press that application.
Otherwise, in that IA itself, that issue can be.
This is over. Doesn't matter to you.
No, sir.
You just need security.
No, sir.
For that, you are given you liberty to move the trial court in an appropriate manner. Sections I have not quoted.
No, sir.
Because that I can't do. I can't advise you.
No, sir. And no, sir, one more prayer, no, sir. or any objections as permissible under the lordship. Any objections as to the lordship stay? As
No,
permissible under.
the stay is over. The stay is over. You can. But you say, there are judicial precedents, I'll tell you.
Lordship.
He's cited one. This is, what do you call this? Mulchand Yadav. So this is one of the leading cases. We also refer to it. Just why when Raja Bull and Sugar came, I said this. There are many orders. Even I have authored. Once there is an execution application, it can't be permitted to be revived, so that the execution takes place and the appeal becomes a paper decree, paper appeal.
Lordship. That
can't happen.
That is their lordship. Otherwise, also there's a lordship has already is aware lordship. There's a judgment of Honorable Supreme Court. The education lordship, until there's a lordship prima facie case in the appeal lordship.
Oh no! Now you have a better chance. Now there's certain new development which has come in.
Lordship.
The Supreme Court has now ordered that every execution petition should be disposed of within 6 months.
There's the lordship, but education has to be lordship disposed within a period of 6 months.
So that's not permissible. The lordships, when they were passing an order, were perhaps not informed about the proceedings under order. The real way in this proceedings under order 41, rule 97, 98 and 101 are taken up. It shall proceed as a suit.
Lordship.
Those provisions are interpreted, and it's the provision of law also says it shall proceed as a suit. A suit cannot be ordered to be disposed of within 6 months. So I have my reservations. I have to obey that order. But as in a critical analysis, that at least I'm bound by it, but I can't support it.
Lordship.
I'm bound by it. I have to obey the order of the Supreme Court. But
otherwise, lordship, one more prayer. If liberty by way of observation, that for vacations of this interim order,
that's never banned.
If that observation is made, otherwise.
No, but you see, the problem is that if the court gives those liberty,
Lordship.
that means I would be overlooking many judgments, including my own orders.
Lordship.
Where I said that order 41 rule 5 is imperative. It must be stayed.
Lordship.
Therefore, that liberty is very difficult. I have given you liberty in a different mode. You can have security.
Okay.
No limitations.
That's it, lordship.
When it comes to this this provision, at least.
Otherwise, lordship, learned court below may lordship have like come to a conclusion that lordship, this if security is lordship punished, then lordship this honor court is endorsing the judgment is a correct law. The order is a correct lordship.
But we have not interfered. We have made a remark. We approve of it.
Lordship. So therefore, because to get it vacated, lordship, to get it vacated is lordship.
You can't get it vacated. You can't get it vacated.
Lordship. If it's not pit case at all, lordship.
No, I'm giving you just show me an example. I may be wrong in giving an example of a house. A man may be occupying it illegally, but he has filed an appeal for some reason. Can the house be allowed?
I understood.
Can the house be allowed to be demolished, and then therefore there is nothing remains in the appeal then? That's the difficulty. Okay. You see, that is why the first order starts in this order, that this will not be treated as 226. 226 against order of civil court is not maintainable.
Correct. I'm very thankful, lordship, for this. Otherwise, I was under impression, lordship, because of this rice case, lordship.
No, I understand, but you see, what happens is that, sitting this side, we always get, updated by the learned council. If I may have missed something, you will definitely bring it and show it to me, and therefore I upgrade my skill. Every time when I sit here, I upgrade my skill. So that's the issue. When we come to know about things, then we, particular subject which I am acquainted with, I can tell you what has happened. You have seen that 7-judge bench, observation of 7-judge bench.
Lordship.
You have seen that?
Lordship.
After that 9 bench, they have
Nine
referred.
bench.
It's very clear. Conceptually, I am very clear on that.